It happens sometimes.
Oh, hi, Cindy Hansen. Nice. Kelly Tatioli. Hi. Nice to meet you.
Yeah.
Very nice of you.
Everybody else gets.
How are you?
Love to see how it goes.
I'm the
I'll take that. I'll take that. I'll take that. So,
Union Middle.
Oh,
All the information of all the dirty details. Yeah. I'm very supportive.
Even tougher.
you know what I mean? I was an observer of that. I could occasionally would say it one or two times.
Really hard to get. I can't tell you how many people I've met everywhere though. Oh, it's a great training. Yeah. What an ordeal. Seriously.
Can you do one crawling thing for me? Can you come and plug Angie's thing into it?
Yeah.
That thing right there? That's where she's sitting.
We're doing what?
Just unplug one of those and put her cord in, if it fits, I hope.
Yeah, they really, the superintendent was saying yesterday that he hasn't gotten one email right now.
Yeah. I mean, you hit it right on.
But they're great, you give them information and explain why.
It's for Angie.
Okay, thanks.
Look forward to hearing your
Thanks.
presentation. Not that it's not like a big
I am supposed
Yeah,
presentation.
here's my PowerPoint.
Yes.
Bless your heart for giving me this paper copy. It's always hard for me to, I can't move fast enough between screens or
fun.
Thank you,
to
Jeff.
follow it very well on the.
Chloe and James. That's why I stuttered.
There are all these other people doing the right
Left in school this morning. Two dogs.
Good to be back here with some power.
That was a nice, that's a week and a half or something, isn't it? They were here, they were here in the summer. Oh, but they haven't been here all this time. Yeah, but they'll be for Thanksgiving. Oh, they're leaving. Yes, yes. Yeah, and they've been there, so then I get them, they get to stay with me for a month. It's really awful. Yeah. That's right, you told me
I don't really know if I need this. I always.
Yes, yes. No, I do whatever it takes right now to be nice to go to. I know.
Okay. Oh, thanks. Oh, Dan Harper. There's Dan.
Which is good. I'll
The only one I know.
So I'm like, okay, Chloe, give me a list.
Oh dear.
Taoli. I just said it like that. Tao Taoli. And then Cindy Hansen.
Okay. Peeps.
This is the principal.
Oh, thank you.
Write names for everybody else.
Oh, good, thank you, thank you.
Just so you know, like, I'll be taking them down.
Yeah, for sure.
So,
I kind of was going to rely on notes.
They should be right, but just I'll keep it here too. So
Okay, thank you.
They have those.
I just don't know.
Oh, I kind of was thinking it should be
I just assumed.
marathon. I'm thinking between marathon.
I don't know, because I just put the picture.
It could be. It depends. The only kind of wild card is that third-party provider list.
I'm a big,
Thank you.
through Orton.
I don't know, I could make a wild card out of any of these.
Yeah.
Well, maybe the most,
We'll see if you guys.
the most wild of the wild
Okay,
cards.
my bag of chips if you get done before.
Okay, let's get started. Let's see. Let's get this show on the road. Are we recording? Pre-recording. We are recording. You are in the Law and Licensing Committee, if that's where you wanted to be, I hope. I guess whether or not that's where you wanted to be. My name's Carol Lear. I'm a board member from District 7, and I'm the chair of this committee. And just ask the other committee members to introduce themselves. Brittany?
Board Member Brittany Cummins, District 6.
And Board Member Mike Haynes, District 11.
Angie Stallings, Deputy Superintendent of Policy with the State Board of Education.
Cindy Davis, District 9. But
Go ahead.
I love what Laura Belknap always says, but I care about every school in the state.
Jenny Earl, District 1, which is northern Utah. So.
Okay, then. I'm not one who needs to have the audience introduce themselves, but I want you to know that we have a pretty informal meeting here. So if you have something to say or you think we're getting something wrong, feel free to raise your hand and I will, maybe if I don't know your name, I'll just recognize you. But we'd like to make sure that everyone who has an opinion has it heard at the appropriate time. So we are moving now to an action item on, which is number 1. And I was looking for these item numbers to be numbered, but they're not. This is a request for a waiver from Board Rule R277-419-4, which comes to us from Canyon School District. And so with that, would you like to give the background or?
Sure.
Thank you.
I'd be happy to. And we've got 3 guests here from Canyons who can probably provide the facts and background even much better than I can. But in short, Union Middle School, the middle school in Canyon School District, had a fire. And due to the fire, a portion of their building was unusable. So they went to a split schedule. So some of their students would come for one portion of the day and the other. So based on the fire, they've made some accommodations to the time and the days that they'll be providing instruction. So as you all know, in our R277-419, the board requires schools to provide 990 hours of instruction over 180 days. And if a district or charter would like an exception to that, then they come to you if it includes 2 or more days. And just as another reminder, we do have provisions in 419, which actually we are going to be asking to move into 121. It's the next agenda item about closures due to emergencies, snow, weather, et cetera. And the superintendent currently has the authority to give 1 day, a waiver for 1 day. But if there's a request for 2 or more days, then currently the board has to approve that request. And so that's why Canyons is here today, because at the end of the day, they will meet their 990-hour requirement, but they won't meet the 180 school day requirement as defined in our board rule. And so that's the background. And I like I said, they're here and they could speak
Sure.
to
Please come
proposal.
forward. Dan and friends? And pull up another chair, sure. And then just if you'll please introduce yourself, just because we're recording the meeting.
Dan Harper.
You
Sorry.
don't have to get close, though.
Dan Harper, General Counsel for the Canyon School District.
And I'm Kelly Tautieli, the principal of Union Middle.
And I'm Cindy Hansen. I'm the Director of School Performance for Middle Schools.
Thank you for being here. So do you need to add, or what would you like to add to what Angie Stallings has said?
So as a result of the fire, we had to close the school completely for 3 days while they did a very intensive cleanup. Then afterwards, the risk management determined that only half of the school would be available because of all the smoke damage. So that's why we went to the split schedule. The split schedule just ended, and since coming back from Thanksgiving, they're back now to a normal schedule. But as a result, the split schedule was just slightly shorter than a 4-hour day that would qualify as a day. So I believe that was 21 days that they were on the reduced schedule. But they still went to all their core classes. So it's been a challenge. The community's been really great and supportive and understanding of the challenges that the middle school has faced. But we're requesting a waiver because we will be very short of the 180-day between the 21 days, half shortened days, and the 3 full days will be 24 days short. But by making certain changes, we still will be able to meet the 990 hours.
You had a somewhat complicated formula for how you're going to have your hours met. Kelly, do you have anything else, or Cindy?
I was just going to say, we can, we're able to squeeze more time out of our days, and we're forfeiting some of our late start Fridays, which is our IPLC time. You hate to give that up, but so we're not having to add any days to our calendar or any weekends. That's not popular with teachers or parents, and so I think it's about the best we can do this year, maybe.
Yeah, and just, they've done everything they can to try to accommodate the needs of the kids. They really put the students first and their safety, and so we're proud of all the things that they've done, and we feel like this is a good solution.
So do you have any problem with having if the committee members have any questions for you folks?
No, we're happy to answer anything.
Okay, any committee member questions?
I don't have a question, but my goodness, I can't even imagine being closed for that 21 days and having to try to adjust that schedule. So hats off to you for making it work and doing what you guys had to do. So thank you.
Okay then, any other comments? Back and forth, anybody in the audience want to weigh in on Canyon School District? Never mind. Okay, do I have a motion? Anybody on the committee? Brittany?
I move that we approve the request for a waiver by Canyon School District from Board Rule R277419-4.
And the motion is that that the committee approve a waiver from R277-419-4 as requested by Canyon School District, meets the hour requirement, not the day requirement. Any further discussion? Let me just say that I'm not usually in favor of these waivers, but they seem to keep coming for legitimate reasons. I wish we could find a way to adjust the board rules so that it wouldn't, I don't like the idea of waiving rules, which is like waiving the law, but I don't, on the same token, it doesn't make any sense to torture you or your students and make them go till the middle of June, so. All in favor of the motion? Then.
Aye.
Aye. And obviously not any opposed, so that's unanimous. Thank you. Thanks, you guys, for
Thank you.
coming.
Thank
you.
I appreciate that.
Appreciate it.
Kind of painless.
Thank you.
Thank you. The next item is related, so we will go to an action item that's a discussion of the Administrative Rule R277-121, which is a sort of a streamlined process, as I understand it, for making these kinds of adjustments going forward. Angie, do you want to speak to that?
Yes, I'd love to, thank you. So a couple of months ago, we had a waiver request, and during that meeting, some questions about how maybe we could revamp or make better the process of our waivers. And one thing we don't have today, but we could bring in January or at another meeting, accompanying this rule is our AAG, Michelle Buse, did a bunch of research that's really helpful on the historical practice of waivers from board rule, who received them, the ones that are in effect right now. She's got some forms that are kind of something that'll be more user-friendly for our districts and our charters that want to seek a waiver. We're also planning to put a lot of those materials up on our website. And our AAGs, Brian and Michelle, will be the point people moving forward on if an LEA wants to seek a waiver from board rule, they would reach out to Michelle and Brian. They'll help draft the agreement, which has been the practice for a couple of years now. And then Michelle and Brian would work with our teaching and learning staff if there's a question of whether the waiver should have a recommendation or not. Because sometimes there may be a waiver that there could be a question about how it may impact student performance, for example, or if the school's performance is lower than you'd expect. But I just wanted to give you that background. That's not what we're talking about today. It was more by way of information that a lot of work has been going on behind the scenes to make this process better. And I just wanted to publicly acknowledge a lot of that work was done by Michelle Buse. She's fantastic. And Brian. Brian has been doing all of these agreements for a long time now. So we'll move forward with that. Kathy will be supporting them by getting those on the website. And then they may or may not. One of the discussion points actually so that was a little bit more background than you wanted, and I'll try to stay brief. But related to that, we asked whether our rule needed to be updated along with the process of trying to make things easier for people to find on our website. And we convened a stakeholder group together. Terry Shoemaker's here. He came and he provided feedback. We had Race Van Tassel. We had State Charter School Board staff and others. Board member Linda Hansen participated in the meeting and provided feedback also. And based on that meeting, updated the board rule as you see here. And so in general, it just kind of gives some, like you said, Board Member Lear, some streamline or clarifications to provide more guidance on what the board would like to see as we're getting requests for waivers. Something that we also noticed is we have an example like today where most of our emergency closures often are just one day or maybe two in an extreme circumstance because of big snowstorms or something. But right now, 419 includes the section of code on snow, inclement weather, or other emergency school closure days. So if you look starting on line 68 of this rule, all of that language, although it's new to 121, it's almost word for word what's currently in 419.12. So some of the feedback is, why don't we include this emergency closures into our board waiver rules so it's all in the same place, to make it easier for people to know where they go if they're seeking a waiver. Currently, if a district or charter wants to seek a waiver for one day and it's due to snow, inclement weather, or other emergency school closure, Superintendent Dickson can, on her own, grant that one-day waiver. And if it's 2 days or more, it comes to you all. One thing that another group, so again, we had a group that met about a month and a half ago to revamp this rule. And then this week, we met with superintendents and a couple of charter representatives, and they have some additional recommendations to make that I did not include in this. And I don't want to speak for Terry, and you can represent the group if you'd like. But one of the recommendations was that all of this section 5 on snow, inclement weather, or other emergency school closure days, that the board could delegate to the superintendent, not just for one day, but for any number of days. And so I'll let Terry speak to that on their behalf. But that's essentially the background on the changes to 121. And I'd be happy to answer any questions. And there you go.
Yep, okay. Board members, do you have any questions on R277-121? Board Member Cummins.
I would be in favor of looking at a rule that delegates this to the superintendent. Snow day, these emergency type situations. But I do have a question on line 77, where it says adequate contingency school days. Is there a threshold? Because I know most schools plan for one. Is one adequate? And is that kind of what our benchmark is? Is the assumption that one is good enough if they run into?
I think they've had 2 or 3 in the past is kind of what the expectation has been, but you're right, that's a subjective term.
Well, in my kind of recollection and experience, both on the board and before, is that was up to LEAs, that some of them are more, some of them have had more snow problems than others, and so some add 1, some add 0. And even though they're supposed to have some, and there's also been no monitoring or punishment or anything else for failure to have enough or anything else. So I'm sort of okay with adequate because it's been so loosely monitored in the past. If you have an offer.
My suggestion is maybe, because I don't think this rule is up for anything immediate, right? It's kind of would be to possibly look at delegating this responsibility fully to the superintendent and allowing the superintendent to have the leeway to make a judgment call and not necessarily put in adequate, but did they have a contingency plan? And, because when you talk about numbers, it's always subjective. Is 1 enough? Is 10 enough? But do they have a plan for snow days at all? What does that look like? Do they have a plan for emergencies? And, how did that plan play in? So you take fire, for example, do we anticipate that something can happen? And if it does happen, they obviously went to a split day. Was that part of a plan, or did they think that up right at the end? Because I would imagine that there was somebody who had that idea before this emergency took place, right? And so it's just addressing, so to the superintendent that says, okay, we had this emergency, here was our plan to address it, and, we're going to need some leeway to the number of days, period. And so.
Just to ask you a question, this is for one board member, but somebody else may have a response too. Is there any point at which you feel like the board should address it rather than the superintendent?
I would think that if they want to appeal it to the board.
Only on an appeal.
Yeah, an appeal to the board if the superintendent denies it, but then leaving the other waivers, like permanent, waivers where they want a four-day week, et cetera, that those would be a board. But these emergency type things, I think, could be left to the superintendent, and that's just my opinion.
Board Member Davis?
Yeah, I thought that the superintendent already had this because when Lake Mountain didn't open on time, they went to superintendent and said, we're going to be this many days out. Can we waive those days? And she said, no, I will not approve that. And so they went back and created another plan, which was a hybrid of blended learning online and then busing students in to have a couple of hours each day of questions answered, of the curriculum done online on Canvas, and that one she approved. So why are we having this discussion if that is already in practice?
And did you say a previous superintendent did that?
It was this year.
That was Sid.
She
Okay,
didn't.
Go ahead.
But she didn't deny it. She said she didn't have the authority to approve it. And they instead went back and decided, so the difference is their second plan was actually providing instruction just through an online model versus having to actually get a waiver. But no,
I was told she denied the first request, so.
No,
Maybe the communication.
Maybe it was communication.
I think I remember seeing the emails where she just said that you'd have to come to the board for that, to get that.
I didn't see, I can't remember.
Yeah.
I mean, I vaguely
But
remember that.
we could look at the emails.
I don't need to look at the
would you
email,
like to
it
speak?
answers the question. If we
Would
need
you
the
like to
rule.
add to our discussion? That's what I'm asking. Please.
So on Wednesday, when we met and discussed, I think Brittany just gave our argument. So thank you, Board Member Cummins, for giving the argument that I was going to give, to go ahead and take these types of waivers and give them to the superintendent. It just makes sense. I think there are others, like the 4-day-a-week thing, that really should be the board. we're talking about all school year. That's one that maybe you should look at, but these others, these emergency situations, we would urge you to alter the rule however you need to do so. Maybe send it back to this committee for some other work or whatever you need to do so that this portion on line 71, which gives her the authority, at least presently, the superintendent authority for one school day to be one or more with the appropriate language. I think that's just the right thing to do. It also keeps the local board involved. I think you want the local board to be involved in this conversation, very much so. Rather than have it only done here, I think that's probably the right thing to do. So I'm not sure unless you have other questions for me. I think this is the right, I think what you outlined, Board Member Cummins, is exactly the right thing to do for this particular rule under those circumstances, which are emergency circumstances.
Is there consensus among the superintendents about that?
Well, there was
Still?
consensus amongst that group. We didn't take a vote
Yeah.
amongst everybody.
No, I wasn't
Yeah,
expecting a
but-
poll. I
but,
just
Thank
wondered-
you, Chair, but there's enough of a consensus that I have no worry about
Okay.
that, okay? I think it's just an extra layer here that frankly could be held, save time, involve the board more, the local boards more, and actually allow you to spend more time on other more, other policy decisions that might have greater significance, rather than how do we handle when they miss 2 days because of a snow closure. I just think it's just better for everybody involved.
You have strong feelings, or was part of your discussion about the contingency plans? Because as far as I'm concerned, I don't know that I don't have a huge desire to say you have to have a contingency plan when it's so poorly monitored or not monitored at all, or
Right, what you heard is several contingency plans,
gone
even
awry,
amongst
too.
this conversation right here. And I think all of those are okay. That's why I think you want the local board involved in the conversation. And I think, and frankly, some of those are very, very creative and maybe not correct, but the superintendent could correct that. But maybe they are, and we just haven't considered them because things are changing in our world and how we do education in so many different ways, particularly with the use of online services. And so I just think we just need to leave that portion more flexible, given individual circumstance. We just had Canyons and the situation there. Who would have thought that one? Okay.
And the only, just in the spirit of conversation, the hangup I have is 1 day, 2 day, I don't know what my breaking point is, but a few days, I don't have a problem with. Where I get a little troubled is if it turns into 21 days or 2 months, and then the funding that goes to the school. I mean, if the teachers aren't working, or if providing an online education is in a very abbreviated way is a lot cheaper, but they've still got the infrastructure in place, and I think it gets a little more complicated with
Well, I think the more days,
more days.
I wouldn't disagree with you on that. I'm more in line thinking about the more common ones, which are 1, 2,
Right.
3, rarely
Couple,
4.
A few.
Okay, I mean, I just think you could decide what those parameters are here if you wanted to do so, but I think giving the superintendent authority to deal with those things is frankly good policy for you, for the vast majority of the circumstances
More
we're talking
efficient.
about.
That sounds true. Any other, Cindy, go ahead.
I'm going to make a motion.
Oh, okay. Anybody else have any more? I just want to make sure everybody is heard, and then, go ahead, we can discuss it after your motion.
I move that the committee approve R277-121 minus the words on line 71 for one school day. Draft 1 on first reading and forward to the board for approval on second and final reading.
So, the motion, go ahead, Angie.
If we wanted to do an appeals process and have essentially what I'm hearing, it sounds like everybody wants, I think that I probably should rewrite this and bring it back next month.
I withdraw the motion.
If you don't mind. There's no hurry, and I would hate to go to the full board, and then we have to have this huge discussion. I think
can amend.
Is that okay? Okay. Yeah.
I'll change it.
Okay. You want to make another motion?
I'll make another motion. I move that the committee send R277-121, draft 1 back for the revisions that have been discussed here today,
Thank you. Do we
and be brought back in January.
second? Do we need a second in committee? I forgot.
Don't really have to direct me to do it. but
Okay.
if you- it's up to you.
Without objection, then, all in favor of that approach, say aye.
Aye.
Aye. We'll go back to the drawing board with the, not totally to be redrawn, but to be revised by staff and then returned in January to the committee.
Perfect.
Thanks. Thanks for your comments, Terry. The next item on the agenda is, I don't see Jeff. Should I skip over that?
Yeah, why don't we do 6:13?
Okay. Next item on the agenda, 7.4, is R277-613, LEA Disruptive Student
Scott
Behavior.
Hansen wanted me to text him for that one, but now we're skipping an item, so now he's got to be up here really fast. Can we go to the next one and then come back to that one?
Oh, and this, we're looking for 613. Who were you supposed to text?
Wanted to
Oh.
talk about it. Let me see if he can come.
Okay. Well, because the next ones
Or
are,
Jeff could come up, we could do 100.
why don't we see who comes first, and then we'll, we'll go with that item on the agenda.
Okay, why don't I can introduce 100
Okay,
while
please.
Jeff comes up.
So contradiction or correction
Yes.
for the record, we're going to go to item 7.3, R277-100, which is the rule of definitions.
Yes. So just as a reminder, last month, or actually 2 months ago, this committee approved a draft of R277-609. That was the rule that talks about physical restraints, exclusionary timeouts. You probably remember that rule. When 609 went to the full board last month, the question was brought up about the definition of suspension.
Jeff wins the
So
lottery.
I'm just pulling it up right now. And instead of amending 609 to include the definition of suspension, the question was whether that term should be defined in R277-100 and therefore apply to all of our rules. And so that is what is before you today, is now the definition of suspension to be included in R277-100. And so Jeff, if you want to kind of give the background.
Line 150,
Yeah,
just for
150.
anybody's information who's isn't looking up, is looking at your own computer. Go ahead.
Right.
Please, Mr. Van Holten.
Jeff Van Holten, Policy Advisor for the board. So you've got the definition of suspension here in Rule 100. As you may recall the discussion in board meeting last month, there were some concerns around timing, essentially, where if you took a student out and talked to them in the hallway based on the definition we had, that technically would have been a suspension. So we were trying to rework in the board meeting some concepts with what suspension could be or not be, and we decided it would make better sense, actually per the motion of Vice Chair Cummins, to put this in Rule 100. Just for context, there is no definition in statute or in code, and this term is used quite a bit in several pieces of code and rules, so it does make sense to put it here in Rule 100. The definition in particular before you, what we did discover when I was working with Michelle Buse, who's not in here, but it's very difficult to define suspension without splitting out in-school and out-of-school suspension. And due to a lot of the rulings from OCR and on the federal government side, it's very difficult to make a blanket statement about out-of-school suspension without taking into consideration students on a 504 or an IEP, because suspension actually does mean something different, and you have different requirements for those students when you remove them from the traditional educational setting. So with all of that in mind, you will see in 30A our definition for in-school suspension. We did put a timeline in there so that it would be at least a half day. So this conversation of out in the hall for a moment is not going to fall into the consideration of a suspension. And then you have out-of-school suspension for the general student population, and then little I and little double I are the students with a 504 or an IEP. Happy to answer any questions. The origin of this language was all pretty much taken directly from OCR and kind of condensed down.
I wondered about that. Thank you. Any other questions? I had one just technical amendment that suddenly occurred to me, but anybody else have any other thoughts? I wondered if we could say at least half a school day on line 152,
Oh, yeah.
so that it isn't 12 hours, it's 3.5 maybe, something like that. And if that's okay, without objection. Board Member Earl.
Yeah, I move that we pass R277-100 definitions for, do I need to read that whole thing? Oh, sorry. That the committee approve R277-100, draft 1, on first reading and forward to the board for approval on second and final reading.
And, great, and I guess I'm just going to assume you'll make that amendment, which is more of a non-substantive one. So the motion is that the committee approve R277-100 definitions for Utah School Board of Education rules on first reading and forward that to the board on final reading, for final reading. All in favor?
Aye.
Oh, I should ask if there's any discussion. Oh, too late. Did anybody have any strong?
Moving right along.
Did anybody have any strong feelings? I don't. I think that everybody's glad to finally have a definition that is hopefully going to be used and consistently applied. And maybe we can forward that to LEAs so they start getting this in the front of their brains. So all in favor? That was aye. And anybody opposed to that? Great. I think it's unanimous. Thank you, Jeff, for your help. With that, we can move on to item 7.4 now, R277-613, LEA Disruptive Student Behavior, Bullying, Cyberbullying, Hazing, Retaliation, and Abusive Conduct Policies and Training for amendment and continuation. So on that, Angie, would you like to start? And Corby Eason, our specialist in that area, would you like to also help Angie? That'd be helpful. Thank you.
Great, and I'll just give a little bit of background of why the rule is back before you. You'll remember a couple of months ago, this rule came to you for the purpose of deleting lines 36 through 38. And then when the rule went before the full board, there was a request, and I believe a motion, to send the rule back to us with the inclusion of a definition for incident. And so if you look at lines 54 through 57, you can see the new incident term that's been included. This, both of these terms come from EdFi definitions, and if you have questions about what that means, I think Corby can speak to that better than I can. But the short story on EdFi is I think the Department of Education contracted with an outside entity to provide data terms and standards for educational entities. We plan to rely on the EdFi standards as we're creating USIMs. And so Corby looked, and others, we looked at the EdFi standards, definitions, et cetera, and this was the definition or definitions that we found. Corby, is that correct, Corby?
Yes, so I work with the data statistic team, and they can speak more about EdFi than I can. That's not my...
And Corby, I think you're supposed to say your name for the
Corby Eason
recording.
from the
Thank you.
State Board of Education.
Thanks.
And so we made sure that these definitions align with everything when we align them with USIMs. And so spoke with them, and they felt like this was a great definition that aligned with everything.
Thank you. Anything you'd like to add to the explanation or discussion or background? Okay, any board member questions? Sure, yes, please. Yeah, that's great. Board Member Hanson, thank you.
Thank you, Scott Hanson, Board Member, District 2. As I looked at this one, I had a couple of concerns. And first, I looked at the stopbullying.org website that the federal government puts out. It appears that when you look at legislation, there are a couple of different approaches to bullying. One of those is to approach it as this activity constitutes bullying and then address those problems. Another is to include protected groups and kind of make it a similar to hate crime kind of legislation, look at the intent of the activity. As you look at, they've got a nice little table that shows which components of the laws are adopted by different states. And Utah is one of the not protected group ones. So they've addressed this just as this behavior constitutes bullying, no matter who is the victim or the aggressor, no matter who the victim is. When I look at.
Hang on just a sec, Scott, just so
Yeah.
I'm clear. You're not talking really about this definition, you're just talking about other provisions in the rule, is that right?
So I'm talking about other provisions of the rule. We include
Okay.
the definition as I looked at the rule, and I don't know if I have the same version that you had, but if you go up a little bit further on that one, you can probably see that.
Which line are you looking at?
So we've got bullying there, and then we go
Line
down.
35?
Then go down below. It's at 35. And we say, we include civil rights violations, rehabilitation, and the version that I looked at also included other languages, other language. Is that on 160? Which had to do with protected classes, race, gender, color. I saw it just a second ago right there, 160, 161.
Uh-huh.
So we have put that into our rule, which is not included in the code. I think that's addressed in other places, other rules. We have the discrimination legislation, of course, and then there's that section F, which I don't know if that's included anywhere in code. And I just wanted to let everyone know that I think that we're moving beyond what the code told us to do with bullying and remind us that we're a rulemaking body, not a legislative body, and I wonder if we're overstepping our bounds. I'm not talking at all about whether that content is appropriate or whether those people are people who may be targeted for bullying and that sort of thing. But I think procedurally, we may have a problem with this rule, and that's what I wanted to bring up.
Board Member Davis.
I should have asked you this earlier when we were chatting about this. So these types of discriminatory behaviors are addressed already in discrimination laws, but are those specific to adults? Do those also protect students in schools from discrimination? I should have thought of that earlier.
We cite all of that federal law, Title VI, Title IX, Section 504. Those are all applicable to students in schools. F is kind of a separate one where we've identified some protected classes, and then we've also identified some areas that are still actively being litigated in the courts. They're not named as protective classes, but there's arguments that they are protected or not. I just wonder if we're getting into an area that maybe we shouldn't with this rule, and I know that I believe in the past we've overstepped and we've kind of been reined in on.
For purposes of trying to keep this a little bit organized, we moved off of our incident definition discussion. We'll come back to that in a minute, which is fine. We can do that. We have been processing this rule and this issue for like 3 years, that I recall. And there were good reasons in the very many conversations that I've heard for the language in line 160. And so at least now that Scott brings it up again, Angie, I don't know if you want to speak to it, or Corby, or one of you would like to speak to why parentheses F is written the way it is.
Sure. And you're absolutely correct, Board Member Lear. It took us 18 months from the time the statute passed to actually getting the rule addressed. And we had multiple times we filed, it brought back. We had threats for litigation. We had people send us letters. So there is a lot that went into it, and I'm trying to remember all of it right now, Corby.
I can't possibly
But
remember the whole trail of tears.
Okay, and Brian can bring
Brian,
it in.
we'll get you in a minute. So Angie, you want to speak to it a little bit?
Yes,
Corby can add, then we'll
but I
hear
do
Brian's
remember, I mean, regardless of how the state defines bullying, there are, as you know, federal requirements for reporting also when people that meet, or students that meet some of these demographics are targets of bullying. And so part of this is we've got LEAs who are required to comply with state law as well as federal law. And in some way, there was an expression from the community, the LEAs, to not totally separate those because it somehow sends a message and has people think they don't have to worry about the federal laws that apply that often are very blended in this area. So it was at the request of both education community members as well as people who often fit under these demographics that we include them because, anyway, so hopefully that's helpful background. And I guess what it sounds like you're saying is that the board in our rulemaking, I guess I don't know that I agree that we only in our rulemaking should make statements about state law. I think there are things we do include about federal law in our rules, but I think your point is valid. That the question is, and maybe I'm reading into something more than about what you said, is to maybe have the state requirements be very separate from the federal, is what it sounds like you're saying. But
If I can just comment, and I'm going to have to run back to my
No,
committee.
please.
So my concern is, one, that we're maybe overstepping state law and federal law with F. I think there's
Are
some
you saying
things
we're
in there.
broadening it? Is that what you're saying,
We're
Scott?
broadening and not narrowing in those areas. And also, we're putting our administrators in a position where they need to judge intent on each of these. That's a difficult thing. So if there's a bullying incident, we have to say, was this bullying because of some characteristics of the victim, or was it just a bullying incident? So someone's going to have to judge that, and I'm not sure if that's what we want to do with this particular anti-bullying law. Just something to think about as you guys talk about. I know we'll be able to address this in the full board, but I wanted to get my 2 cents in, and I appreciate that.
Hey, one sec, Brian. I think there's also a possible explanation that says that, and maybe it hinges on changing, maybe it changing the word to, something like it could be based upon, as opposed to, it seems to say it shall be based upon. But I don't necessarily think that it precludes bullying based on these characteristics or just bullying. But I'm thinking out loud. Okay, well, you go back to your committee if you
Okay,
want.
I'll
and
run
then
back,
we
but-
appreciate your
Yeah.
comment. And
Thank you.
I guess 1 or 2 more months may not matter, but we'll see.
one other thing, just Board Member Hanson, this does talk about training. Training on those things, so it's not necessarily providing a civil. Do you know, it's not saying you're now guilty of something, and I don't know if that helps.
Actually, but later on, it uses
The
that same
reporting.
language.
And then reporting has to be check the box. as
259,
to
and you
which
have
of
to
these
report
occurred.
incidents.
The
based on
core
that.
of it is
So
the
you'd have to make
reporting.
a
That's what
judgment.
I was trying to clear up, and it sounds like we've instead muddied
But
it
it's not even
further.
the
Sorry
same
if I
language
muddied
down there,
things
it's a different
That's
language.
right, thanks,
Right,
Scott.
because I think the training is supposed to be broader than the reporting, like.
It certainly could be broader than
That's what- yeah.
than the reporting. But Brian, you want to speak to any of this?
Let me give you a little background. Angie kind of hinted at it. There was a lawsuit brought by Equality Utah a couple of years ago, back when there was reference in state code to homosexuality, and we all might remember that. And there was a bill, SB 196, then the legislature passed, that eliminated prohibitions related to the advocacy of homosexuality and added a prohibition related to the advocacy of premarital and extramarital sexual activity. So that resolved the state statute. In our rule, the board at that time then revised the rule, so then it tracked the new state statute. Also, to resolve the lawsuit, so our board was sued by Equality Utah. To resolve that lawsuit, Chair Huntsman and Superintendent Dickson at that time signed a letter, and this was pretty much there was no formal settlement agreement, and I think I've provided copies to a couple of folks here. And it says in key part, and I'm happy to share this with whoever does not have this. So this is what the board effectively said at that time. This is September of 2017, so about 2 years ago. The State Board of Education desires each student in Utah public schools to receive a high-quality education free from all manner of discrimination, which can take the form of bullying based on religion, race, ethnicity, gender, sexual orientation, and gender identity. So it included those two classes, sexual orientation and gender identity. So that, based on this, we were able to resolve the lawsuit at that time with
Well, it's kind of an
Equality
informal
Utah.
settlement agreement, is
Yeah,
that
I
what you're
think you
saying?
So can I ask a question? So are you saying that those are not covered in federal law?
I did not say that.
Okay, that's what I'm trying to understand what
Well, I
the.
haven't gotten there yet. I'm
Okay,
just
sorry,
trying to
go
say
ahead.
that was the resolution of our
Lawsuit.
lawsuit in the state case. Now, as far as, and I think we all agree that there's no state statute that includes those protected classes. There's no federal statute that includes those protected classes. However, there is some federal guidance that does hit on that. For example, there is this
From
one.
OCS, I'm sorry, from OCR?
This
it
is,
federal
well,
guidance?
this is DOE, Office of Civil Rights, this is January 2001 on Title IX. And so here's what they said, this is the revised sexual harassment guidance. This, as far as I understand, is still on the books. And it states, among other things, although Title IX does not prohibit discrimination on the basis of sexual orientation, so we all understand that. And it says sexual harassment directed at gay or lesbian students that is sufficiently serious to limit or deny a student's ability to participate or benefit from the school's program constitutes sexual harassment prohibited by Title IX. So there is some protection through OCR to based on sexual orientation. So not in federal statute, but based out of OCR. So there,
So Title
it
IX.
is, yeah, under Title IX. So
Okay.
it's not super clean. Like, it'd be super nice if it was in a statute. It's not in a statute. I guess where I'm going is, I think there is basis, and of course, depending on which administration is in the White House, whether it's Democrat or Republican, it seems like it kind of switches every time that switches. But legally, I think this is not conflicting, or it doesn't violate any law to include gender identity or sexual orientation. It does expand, it does kind of go beyond. And I think it can be argued that it does kind of comply with some guidance from OCR.
So let me kind of restate something to you and see if this is what you're saying. Between the OCR guidance and the agreement we made with Equality Utah, there's a justification for using this language in this rule. Is that what you're saying? Okay, go
Okay,
ahead.
so then I
Board
just have
Member
some
Earl.
questions, because I did listen to August's meeting, the Rules Committee, right? So, and I think it kind of goes back to Scott. If we were interested in putting this language in here, which if that's the language we want, if we don't have it in law, I think we should then, we're filing all kinds of bills right now, right? We're making all kinds of intents. Why would we not put that into a bill so that we can have that language so it's consistent across, do you know what I mean? It's in state law. And I'm just curious, because we do cite, at the top, I guess it's not consistent through the whole thing, through the whole document. We give let me go to the top here. We give a definition. Sorry.
In the
We, at
of this
the
rule?
beginning, civil rights violation, we list those, but then we don't give this description on 160. We give that later, and then even at the bottom, but you were saying one's training, one's something else. We even list different incidences to cite. And I guess I wasn't even thinking this direction, because I'm thinking children, I'm thinking a youth setting, and I don't know, maybe your kids are different, but mine I'm thinking might be kind of normal. Sometimes they're not very kind to others. And sometimes, even this happens in my house, they say things that are mean, like, I hate that dress, or or whatever, you know what I mean? And I don't think their intent might have been to harass their sister, but doing that once does not, and does not lead to that, okay, we've got a serious bullying issue here. And then the other thing is, and I personally done this where I've said, oh, so when are you expecting? Based on my perceptions, and misrepresented the fact that someone wasn't actually pregnant. So do you know what I'm saying? So I'm trying to understand the balance in
talks
here.
about that.
What talks about that?
What you just said
The
is
OCR
perfectly,
guidance.
and it says,
But
it has to
okay.
be it has to be severe, and the harassment, it can't just be a simple,
Do
like
we
what
do
you
that
just
here?
said. So for example, it says, on the other hand, if students heckle another student with comments based on the student's sexual orientation, for example, quote, gay students are not welcomed at this table in the cafeteria, but their actions do not involve conduct of a sexual nature, their actions would not be sexual harassment covered by Title IX. So there's kind of a threshold, there's kind of low level, I think what you were just explaining, and then there's the higher.
Well, and to kind of take it one step further, the U.S. Supreme Court has defined harassment, sexual harassment is something that's severe, objectively offensive,
that's right.
and persistent from the
Right.
Davis case. So it's not, if we're using that standard, it's not any demeaning comment or teasing comment. It raises it to a new level, which is the intent or the focus of this particular situation.
So then I do have, I mean, just the way it's outlined here is not correct, then, if I'm understanding what you're saying, because we have it as a separate item. It's under F, right? It's a separate item. It's not even under 9.
Well, I think we're talking about a couple of different things. The purpose of the change is to, the purpose of the change is even narrower than this, but it's to tell LEAs, which they have to do, we have to have a report to the federal government of bullying incidents in order to get federal money. So we're trying to give a consistent definition, not only of what we just talked about, bullying, harassment, cyberbullying. We have to have a consistent definition of that. But secondly, we need a consistent definition of an incident. Because our question, the LEA question has often been, 8 kids are involved, so do you have 8 incidents in or do you
Yeah,
have?
I get that.
Yeah,
I
that
get
part,
that.
so
Yeah,
that's
yeah,
one
yeah.
piece of
That's
it.
not-
But the other piece of it is what you're describing, which is what we talked about for 18 months. But let's see what, first Cindy has to add and then Angie.
So we have this definition of bullying, which are the behaviors. Then we have
Everybody's trying to-
discrimination.
But take us to the line number. So
Well,
I'm
I'm just conceptually
Okay, all right.
saying,
Okay.
if we are trying to combine the act of bullying, which involves all of this and much more, and then add the discrimination piece, which is covered under different laws for reporting and training purposes, then maybe we should just define that in language somewhere, that these are being combined for reporting and training purposes. And why would they sue the board and not sue the legislative? They did sue.
You can't.
They sued both, but then the code wasn't
Not
changed.
the
Can't sue the
legislature.
legislature.
You can't sue the legislature, but you,
They,
sue about the
They did.
statute.
well, they,
Didn't they?
no.
Yeah.
It involved the statute, but the legislature pretty quickly revised.
It was our board rule that that the focus was on from Equality Utah.
because we didn't include language from discrimination laws in our bullying policy.
Can I say
Yes,
something?
speak to that,
So
Angie.
the original litigation was actually about our sex ed rule, the 474. But then, and we resolved that. And then a couple months later, we were working on 613, and they came back and said, we felt like that settlement also applied to 613. It was essentially saying, this statement is not limited to one rule, but what the lawsuit started out by was related, the words were exactly 474, my recollection. Do you remember that, Ryan?
I'll defer to your memory. You've
Okay.
always.
But, so what they were saying in their lawsuit, it wasn't just about one rule, it was the concept in general. And then they felt like it applied to both 474 and 613. That was my recollection.
And we did agree, whether we like it or not exactly now, but the board did agree at the time that it would amend both this rule and the other rule number, which I can't remember.
I'd like to make a motion.
Regardless of whether we had to or not, the board did agree to amend the language on both rules. So Cindy, did you have more to add?
I'd like to make a motion.
Okay. Did you have something else, Angie?
Well, The only mention I was going to make, Board Member Earl, is that when this rule went before administrative rules in August, the only thing they talked about the whole time was lines 36 through 38. So they didn't raise any, the legislative body didn't raise any of these other issues at that time, so.
Okay, because it was part, I mean, that's part of the dialogue I heard when I listened to it, that was talked about.
They were focused on those
They
three
did-
lines.
They did primarily focus on that. It was there was other dialogue along that lines too, and concerns with that and going beyond. So I did listen to it this week because I was trying to understand why we had this coming back fully.
Sure.
So, which is,
Different. I think the reason why they really focused on this definition is that the board actually has quite a few, and that's why you'll see all of the sections of code in lines 6 through 18 added, is there are many sections of code that direct the board to establish standards for training related to bullying, minimum standards for public schools, including discipline and control, how students participate, and you can see them all there, right? And so I think that authority, those other sections of code give the board quite extensive authority beyond just bullying to talk about how kids relate to kids, how we protect kids, et cetera. And versus what they were upset about, it was this very narrow issue of they already had a definition of bullying, and by us including those lines, we're changing their definition of bullying. So I agree with you, there was some rhetoric about there's these other things that happen, but we also, meaning the board, has quite a bit of authority to supplement things that the legislature has directed in all of these other sections of code. So it's a lot easier to say, the statute has this definition of bullying. If the board then redefines it, it's easy for the legislature to say there's a conflict. But the next question is, if the legislature establishes a standard, because of all these other sections of code, does the board have the authority to go beyond that or to add? And I, being your counsel and always being an advocate for the board's authority, of course, would say, I believe you do. I understand if whatever we have gone beyond with, you may want to change, but I think that's why the legislature maybe didn't get into that. There's always this difficult struggle we have with the legislature, because on one hand, they love in some areas when we do supplement or when we're proactive about items and they don't have to deal with it in statute. But other times, as you know, there's times that the board does act or supplements, and at least a certain portion of the legislature doesn't like. So I would just say we're happy to do whatever the board wants. If the board would like us to do something, we can do it.
Let's move to Cindy's motion and see if this helps.
I don't know if it's going to help. And you may not like this. It's going to be more work. But I move that the committee moves that the board asks staff to work on draft legislation to consider adding that discrimination definition into its bullying code. And I'd like to speak to the motion.
Go ahead and speak to it.
This has been a tricky issue for me the whole time we've been talking about this, because I think we really have a responsibility to protect students. And I've questioned some of the back and forthing between administrative rules and our, board, and but I do, having looked at all of Scott's, Board Member Hansen's paperwork prior to this meeting, I felt like there was enough compelling evidence to at least try in that one category, it's like 5 lines of our thing where we describe that discrimination,
And where are you talking about, Cindy? Which lines? Which 5 lines? The line beginning on line 45 or beginning in the definition of bullying?
It has a header of discrimination.
And it's on line which?
It's where it is. Let me go back in and try to find it.
Is it in the definitions or no? No.
Let me go back in and try to find it. He should have left his papers here. Oh, it's on line 42, it's civil rights violation. And then it's,
So civil rights violation means its whole definition going down through
no, just,
line,
yeah.
through
just-
line 48?
Gosh, I need to get him back up here. Let me go down a little bit more so I can see if I can find another spot that was more clear. I was looking at his paper copy, and I think it's a little different with this one. Okay, so it's lines 160 through 163.
160 through 163.
160 through 163.
Right. Okay, go ahead.
It would be nice if they would include that also in code, in their definitions, so that we could be more consistent with what they are doing. And when you look at Board Member Hanson's charts, he has this kind of grid on which laws are about which things. And I just think we should ask. They can say no, but I think we at least can ask them and talk to them too about this lawsuit and explain the reasons why. But I think it would be good to ask them to consider.
Okay.
So that we can be more consistent with code.
Let me go first, Brittany, and then I want to see if Corby has anything to add, and then I have a comment too. So, Board Member Cummins.
I'm confused by this conversation because we have a definition for bullying. And bullying, the definition for bullying doesn't talk about any protected classes or individuals. It just talks about employees and students, right?
About behavior.
It's about behavior. And so I'm confused as to why we're not talking about why it's not okay to inform teachers about certain places where they might see these types of behaviors in classrooms and on playgrounds. Why is it inappropriate for them to say, you know what, you might see bullying in relation to a characteristic. You know, you hear all the time students picking a characteristic of a student and putting a name to it of some kind and saying, you know, you're this or you're that. Whether it's perceived or real, it doesn't matter. And why is that okay for a student to do that? And so why can't we put in this rule? Correct, it's not.
okay.
And so why can't we put this in the rule that here are some places for teachers to look for these bullying behaviors? Because I don't see that we're defining anything as other than here are some circumstances that you might see where you're looking at any child who doesn't fit a stereotype of some kind. Why is that? Can you look for those areas? Because that could be a place where you might find bullying. It might be a one-off comment, but you also, those are the most vulnerable places where you're going to find those aggressions and those bullying behaviors where it becomes ongoing and problematic.
I'd like to respond.
And please.
I totally agree with you. Like, I don't disagree at all. I just remember us being called, and maybe if the Rules Committee had a problem with these specific lines, they would have asked us to change those specific lines, and that certainly is something that should be considered by this committee as well. But just in light of the comments that we heard today and looking across the laws in general, what we took out before were examples and not definitions of behaviors. So help me if I'm misunderstanding.
Sure, back to Brittany.
Okay, so the lines that were removed were part of a definition, and they were about behavior, because it talks about rational aggression, indirect or covert, right? So it's talking about the behavior, so it was expanding the definition, not looking at areas where bullying may be, where populations might be most vulnerable to bullying behaviors.
Do we need to
Because
say
the
that
lines that
somewhere?
were removed from the definition section, and they were expanding the definition of bullying to include additional behaviors, not additional places.
And the behavior is defined in 53G-9-601. So I hesitate to agree with anyway, sometimes don't always disagree with the legislature's view of those things, but in this case, it does expand their definition of bullying, which I'm not sure we're entitled to do.
Can we, Chair, may I just add one more? Can we add that language that Board Member Cummins just said? Populations where you may find, or some kind of language like that, because, so it's
Instead of
not.
something or
Well,
right there?
so it's not assumed that that is the definition of bullying.
So, okay, can I?
Brittany.
Sorry, if I can find back where I was. So if we go back to chunk F, sorry, I don't know.
The parentheses F on
F.
line,
And you go back to
that on
where
160?
it
60 to
starts.
163.
It says the training described shall include information on various types of aggression and bullying, including overt aggression that may include physical fighting. And then it goes down to F, bullying, cyberbullying, hazing, and retaliation based on. So it's that based on, and then it lists those vulnerable populations, students or employees, actual perceived characteristics, including race, blah, 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 blah. And so it's talking about those populations where bullying, those vulnerable populations are in a bullying situation, not that this is bullying, but these bullying behaviors exist in these populations frequently.
And I think that was his concern, was the based on, because then you're getting into intent rather than saying some areas where you may see these behaviors are.
would it be remedied? And you had the long conversation with Scott.
I did. I gotta stop trying to get in his head and like he's gonna have to come back up and
talked about this
fight this
forever
fight, I guess,
and
'cause-
talked to school districts about it forever, and I've never found it to be the problem Scott does. So maybe reasonable attorneys can differ, but I wonder if it could be remedied by saying which could be based upon, or which may be based upon, as opposed to which the suggestion here that says must be based upon. But let's try Angie for a
I
minute.
guess I just wonder if you want to postpone this discussion and actually ask Board Member Hanson to sit with Brian, Corby, and I, because I haven't seen all this information. But a lot of what I'm feeling is similar to what Board Member Cummins just said. We are not legally defining bullying versus what isn't bullying. Instead, we're saying, as you do your training, exactly what Board Member Cummins said, those lines do not change the definition of bullying. Instead, they say, here's some areas, here's student populations where you are more likely to find students who are the victims of bullying. It doesn't say, because that student is that makes it bullying versus
Right.
not.
Right.
And so I feel like in some ways it would be really helpful for us to have the same information that you all had, instead of us just talking in circles.
And let me just say, and as taking the prerogative of the chair, let me just say one other thing, and then we'll have another motion. Cindy, I don't know where we are in terms of the previous motion, but we'll just call it.
I withdraw the previous motion and I'll make the next,
Substitute.
the other
We'll
one.
have another motion, but my comment is, we have been working on this for 2 years, and while sometimes I think that's warranted, my greater concern is giving clear direction to LEAs so that they can get their federal money for reporting things consistently. That's my prime directive, is to, and if we can do it by a few words that say such as, or which may be evidenced in, or some things like that, I'm for that. But I personally believe I don't want to go to the legislature. I think we'll get language that's narrower and less protective of students, when I think the state board has the authority to identify, for training purposes, the students, the kind of behavior we want to prohibit in schools.
Okay.
So I want to make, that's my, opinion about that, but I hope I hope we can factor that in, or maybe I'd like to be in that meeting too, I don't know. But I want to give some direction to LEAs after 2 years of wrangling about this, so that it doesn't look like Granite has 10 incidents and North St. Pete has 29.
Agreed.
That's what's been the challenge, and it makes LEAs disinclined to report accurately. And some federal government person somewhere should stop giving us money, because it looks so inconsistent. Jenny, did you have another comment?
I just have, I guess I had a question. So we're supposed to report, I'm looking down on lines 255.
Down at the very bottom.
Yes. So we report, we've got a listing I2, I3, right? We've got those listings that we report on those, right?
A number of incidents, right, described
Right.
in subsection.
And then it
Right.
requires the number of incidents
reporting
on
requirements.
259 and 260 as well?
Those are other reporting requirements, right. They aren't necessarily, the number of incidents is one kind of report. There are other reporting requirements in
so-
Title VI, Title IX, et cetera.
So on 259, 260, I'm sorry, you probably just said this, and I'm not understanding it. You're saying that those are additional reporting requirements that the federal government requires? No, who requires the additional reporting?
We are in this rule. So I think you're bringing up a good point.
Okay,
So
so now
there
I'm
was a
confused.
question of including some of these student demographics that are in F 259. At some point, we had this very argument, is that covered under Title IX or not? Well, if you live in this state, it is, because case law that governs that circuit is clearly stating that it is, but because we're in the 10th Circuit, it doesn't. Because I think one thing that Brian didn't mention, a lot of this, although it's not in statute, often is governed by case law. And in certain areas of the state, in the country, either local communities, again, the federal law has like a requirement, but oftentimes states and communities go beyond that. Like they protect more individuals than the federal government requires. And/or you've got case law that in certain areas of the country, certain circuits have determined certain things that maybe not in the 10th Circuit, which is the federal court circuit we're in. So a lot of this is coming back to me now, Courtney, as we talk about it more and more. So that's why you see report incidents based on those federal laws that fit, but then above and beyond, it was a request. Again, this rule came back many times. We received a lot of public comment. And it was decided that we, the board, in addition to getting collection of bullying based on the federally protected classes, that we also wanted F, those that fall under F, so that we could see if they're vulnerable, regardless of whether it's discrimination based on federal, it's identification of student populations who tend to be vulnerable. And then we could find out, I guess, for training purposes, how to support LEAs in saying, look, you've got, that's it.
Okay, so my last question. So if I understand you, federal law does not require F, but the others require F. We are requiring F. Yes. Okay,
That's right. And consistent with this settlement agreement, related to the settlement agreement that we had from Equality Utah.
I think one.
Yes, I want to make sure that that's not an inaccurate statement. Isn't that true, Brian, that we required?
Written, it's just assumed.
No, I just said, we're requiring this parentheses F, which is on line 160, I believe, because this was something that Equality Utah brought back. It wasn't. Was it only, maybe?
It was a lot of people.
Yeah, it was a lot of.
And so was other stakeholders as well as Equality Utah, but the reason that I'm kind of tying it to Equality Utah is because that involved the settlement of a lawsuit. And we have a comment from the public, but let's go to Corby first, and hang on, Tracy.
Yes, Corby Easton, Prevention Specialist here at the Utah State Board of Education. One of the things that we try to do here as a prevention specialist, we try to provide clear guidance to LEAs. And the LEAs they have been asking for clear guidance on this particular area. And so we just try to support them as much as we can and be preventative, proactive versus reactive.
Thank you. That's what I was saying in longer words.
Yep.
Tracy, Tracy Watson, I'll let you introduce yourself. Might as well have another as a lawyer's opinion.
Tracy Watson, Utah Education Association. I just wanted to piggyback on Angie's comment, just to make it clear for the members of the committee. Paragraph F is actually the state of Utah categories. So under the state of Utah's anti-discrimination law. So the state of Utah affords more categories than the federal law. And F just didn't say including the categories in the state of Utah's, because like Title VII, Title VI, it all applies to employment only, but this rule brought it in for simplicity. So rather than just being the employer, that's why it now applies to students. I think that just is clarification.
I have a question.
Thank you very much. Oh, you want to ask Tracy something?
Well, I'm not sure if it's a question for you, Tracy, but if that is written in state code, is that code referenced in this?
No, because, I'm sorry, let me clarify. Just the categories of protected classes. So state code does not say bullying, cyberbullying, hazing.
No, I see, because this is combining the discrimination and the bullying. But I'd like to have that language referenced so that at least if Rules Committee calls us back up again and says we hate this, we can at least reference back to where this language is in code that Tracy's referring to.
Thank you for that clarification. So now maybe, I can't remember if you made a motion or not. Did you ever make that motion to have it worked on by a work group? Considered by a work group? Or maybe you
I
don't wanna
didn't,
make
but
the
I'm
motion.
ready. I think I'm ready to.
Okay,
So I withdraw my earlier motion.
great.
I did, in visiting with Board Member Hanson, say that this whole combination of the discrimination laws with the bullying definitions could be because of reporting issues. But I would like to ask the committee to direct staff to visit with Board Member Hanson with his federal and state research and just see if we are within where we need to be.
Okay.
Or at least work on any potential changes that could assuage anybody's concerns about conflicts with the laws. Anybody.
Okay, the motion is to repeat that this rule, R277-613, be referred back to staff for further discussion based on other board members' concerns and to make sure that they are met to the best of our ability. And let me just add, and I hope you're okay with this, with some urgency that we're able to resolve this in the next couple of months.
Yes. And also technically that we reference where in the discrimination, in the Utah Discrimination Code, this language is written.
And that appropriate legal references are added. So that's the motion, if everybody kind of followed the sequential phrases. The short version is that R277-613 will be referred back to staff for further work. And all in favor of that motion, say aye. Aye. Any opposed? It's unanimous. Thank you.
Can I make one more comment?
Please.
I apologize. I just wanted to point out that if we don't amend lines 36 through 38 in this rule before the legislative session, there is a possibility they may sunset this rule because they said that. So I'm happy to bring it back, but I can almost guarantee you that whatever we come up with Board Member Hanson will not be ready by the January board meeting. So I will be happy to talk to them about why the board didn't take action on lines 36 through 38. But just know that that could be a risk.
And then my, I don't know where this
Make
fits
that
in
change
in the
first.
discussion of this, but my hope is that this could happen quickly and that even if you're not able to completely resolve the issues, if you can bring it, I don't want to have another discussion with the Administrative Rules Committee either. And so if we could at least have it amended
to some degree, and then if there are other issues, we can continue to work on them. So that because both to give guidance to LEAs and to satisfy the Administrative Rules Committee and the legislature generally. Cindy, did you have something to add too?
No, I'm just thinking Brittany's going to address the timeline there, maybe.
Yeah.
Okay.
So can we approve the amendments that have been made? So the removal of lines 36, blah, 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 and the addition of the definitions, and then go with that motion to bring it back to committee again? So then it would the rule would
be
move forward with
continued.
amendments, but then,
Right.
so can I make that motion?
So the motion is, the additional motion is that on R277-613, that lines,
No, so
it will drop,
draft 3.
we will adopt, the committee the motion is for the committee to adopt draft 3 of R277-613 with direction to staff to continue to work on the other issues. Is that right?
Yeah, so send it to the board for final
For
reading.
final reading next month. Is that what you intended?
Yes.
Thank you. All in favor of that motion, say aye. Aye. Opposed? Clarifying question.
I'm sorry.
I did that a little fast.
Did you say?
We'll take it to the board next month for final reading and then continue to work on the other definitional words. Yes. Angie, do you have a
Yeah,
clarification?
and I'd like to just clarify, because Kathy just asked, does that overrule the last one? And I'd say no, they're two motions.
Right.
So the intent is for draft 3 to pass the board next month so that we can at least get these two, the deletions of those two. And then we will meet, Brian, Corby, and I, and others potentially, with Board Member Hanson, to talk about the more substantive issues that were described today, to see if we need to bring 613 back for a bigger rewrite.
That's great.
And so we'll be doing both.
That was just clarification, not another
that-
motion. Are we all good with that? Okay, the clarification. No, I voted yes on everything. Yes, it was unanimous both times. Thank you. Thanks for your patience. Corby, you've aged at least 10 years in the last couple.
You still look young.
Yes. But thanks for the discussion. Okay, we do have a longer discussion. If it's okay with everybody else, could we address the other two items and then we can move on to the third-party provider? Is that going to upset anyone? I hope not. Item 7.6, is Travis going to be here?
He will, but he probably didn't, he
didn't
probably
know.
thought,
He
I can
thought-
text he and Ben right now.
Okay.
Yeah.
We can go to R2, let's go to item 7.7, because that doesn't take as much discussion. 979, Military Interstate Children's Compact Commission, State Council. This is a new rule. I can pretty much describe this until Angie can help.
Sure.
This is a council, this involves a council that meets to make decisions for military families who are in Utah or moving to Utah. And there is again, a state council in every state that adopts this compact. And it has been under the governor, who maybe hasn't paid as much attention to it as it deserves. And so the thought is that with the governor's blessing, we would put this under the State Board of Education. So, and Ben's here now to add anything he wants to R277-979. I just said it's a state council that will now be under the State Board of Education.
That's
and meet
correct.
annually. Any questions about that? It's pretty benign. Okay, without further discussion then, I will move that the committee passes R277-979.
929.
979, it says.
Oh, it should be two.
929.
Yes, sorry.
That the committee moves, that the committee will recommend R277-929 to the board next month for final passage. Military Interstate Children's Compact Commission, State Council. Any further discussion on that or questions? All in favor? Aye.
Aye.
Great, okay. The next item is is item number 7.6, which is R277-309. It's another licensing rule, has to do with appropriate assignment and licensing of teachers, and a new rule. So Ben and Travis, would you like to introduce yourselves and speak to that?
Ben Rasmussen, Director of Law and Professional Practices.
And Travis Rawlings, the Educator Licensing Coordinator for the State Board of Education.
You want to highlight what's changed?
Yeah, I can go through this. I did also want to give you a little bit of extra feedback that I received after board backup was due. This rule is replacing R277-520, which is under the same name, and basically details the requirements for teachers in various positions. In terms of changes, the only major change, if you will, of what this rule is doing, as opposed to the previous rule, is regarding non-school building principal administrative positions at districts. I was trying to quickly find the exact line of that. It's around line 120, I believe. That essentially, the administrative license has been used as much more than it is intended to be. We've talked about this when we passed the 305 rule. Oh, it is 120. Oh, that's a good guess. We're changing the name of that license to school leadership because it really is intended, it prepares a person to be a principal. It does not prepare a person to be an associate superintendent. That's not what the license does. And so ultimately what this is saying is, while we require this type of license for a principal and a vice principal, if you have any other requirements, district or charter school, for other administrative positions, that's at your discretion. And many districts will say, we want someone with this type of license before we hire them in X position. And some will decide they don't want that, but that would be up to their local position. Everything else in this rule is really a transition of things that we have done under the existing rule and how that might look in the new system. Primarily, the two aspects are eminence and state-approved endorsement plans. Eminence, under the current rule, is something that simply allows an individual to request a letter of authorization if they're teaching 1 or 2 periods a day. The concept being that there is a local professional or there's a university professor that the school wants to invite to teach a limited amount in the school, and they want to use a letter of authorization to qualify them for that. Some of the feedback I did receive on this rule was questioning that practice. It's an argument that we've heard before because eminence, like I said, is not new. But ultimately, the concern was, is teaching less really a ground for less of a standard? And the staff's response to that would be that less of a teaching assignment is more relying on local control. That ultimately, when a person is only coming in to teach 1 period, it is of less concern to the system as a whole than it is of other issues. Principals, districts, charter schools are still required to make sure that those teachers are effective, that they understand ethical and instructional practices. So they still have all those responsibilities. It's simply a matter of saying, in these unique circumstances, we see this as a long-term solution. So that these would not necessarily need to come back to the board every year like they do now. The second thing that will continue is this idea of state-approved endorsement plans. This is a situation where a teacher who has met some of the requirements for an endorsement can receive that endorsement on a temporary basis while they teach, so they can complete all of the requirements. This is fairly common practice that has occurred in our state for a long time. One of the issues that we realized was occurring in the new licensing rule, by requiring the content knowledge test for associate license, that means that you are assuming that the individual is coming with the content knowledge that they need. So when you're bringing a professional from industry or those kind of situations, they have that and they can pass that test. But when a teacher is learning a new content area, they don't have the content yet. They need to take the classes before they can do that. And so ultimately, what this provision says is if you are a professionally licensed teacher, and even if you haven't passed the test yet, if you've met most of the competencies, I think the word we used was significant, then you can receive the associate license. You still have to pass the test to receive the professional, but it allows them to get that associate 2 years, similar to the current practice, to allow them to earn the endorsement. And again, some of the feedback was regarding that concern, or some of the feedback was, if they haven't met all the requirements yet, so why are they being allowed to teach? But again, the response is, this is a limited basis, it's an experienced teacher, they're learning those things, and so it's less of a concern to the system. And ultimately, as I said, most of this is minor in nature. It's a continuance of most practices, so we really didn't receive a lot of feedback on it. And with that, Madam Chair, I'm open to any questions.
Board member comments.
Do you ever get into one of those places where your brain is just not letting you through to figure something out? And so I listened to your explanation just now, and I read on lines 144 through 150, and I've read 1 and 2, and I can't figure out what the difference between them is.
I did get one comment back saying I didn't really understand this until I'd read it 3 times, but I didn't know how to write it differently, but let me.
Okay, so in 143, starting with section 6, I'm assuming.
Right.
Okay, so bullet point 1 is simply saying, if you hold a license area of any type, you can receive additional endorsements by meeting the core requirements. That's 301, that's line 146. The second one is the exception I talked about. The second bullet point is if you are a professional license holder, then you can receive it with this exception to those major rules, that you haven't passed the test yet, but you can still get the associate. That's the difference between the 2 sections.
Go ahead.
Sorry. I apologize. So 301 gives a process for associate moving to professional.
Mhm.
That's what number 2 feels like to me as well, that if I have a professional license, I can get an associate endorsement that would move into a professional endorsement.
And so the difference is it allows me to get the associate endorsement without passing the test.
And by that test, you mean praxis?
The content knowledge test,
So is
yes.
that praxis?
In general, yes.
Yes.
And so in 301, it specifically states you have to pass the content test before you receive it.
Okay. Thank you. That was painful inside my head. I appreciate it.
I'm just glad we answered the question.
Did you kind of know what he's saying now?
Yes, I
Okay.
completely understand. It just, I read through 301 and I tried to find that distinction, but it's just the test that has to be taken later, not at the immediate time when you're getting that
Already a
associate
professional
endorsement.
If you're already a professional.
I should mention too that the person who had a problem with this is this person who often reads my rules and gives me lots of good feedback. So it was not just you. That was.
Let me ask one question, Cindy, related to this if I can, and then I'll come to you. But my question was a little different than Brittany's, but about the same issue exactly. I, for the life of me, couldn't figure out why it matters. Is there money attached to it? There's no, I couldn't see that it matters if you've got an associate endorsement or a professional
Well, you
endorsement.
can't
Can you
So
explain any
the assumption is if
distinction?
they're required to have individuals with licensing.
Yes.
And if they chose not to utilize an LEA-specific license for someone because for whatever reason they didn't feel that was appropriate, they could.
By they, you mean an LEA?
The LEA. They would lose funding based on the fact that the individual wasn't qualified. Because without this provision, you're not going to pass the history praxis test until you've taken the history classes or done some homework, right? And so this is intended to say to that person, okay, district, you can still get your money for 2 years, because that's the length of an associate
Okay, So an
license.
associate license, so an associate endorsement lasts as long as an associate license.
Correct.
Which it doesn't
Correct.
really say
And would
here,
ha-
but.
It doesn't say that here, but the assumption is that the concept of associated, so the length and everything would apply to endorsements and license
So
areas.
it does have money consequences.
Yes, yes.
Brittany, and then I want to go to Cindy.
So just one follow-up question then. So in number 1, where it says "an educator," so that would include a professional licensed educator. So is this saying 1 is inclusive of professional and associate educators? Can you get, if I'm an associate teacher in an English content, right? I just am brand new working through this process. Can I get an associate content endorsement for history at the same time that I'm working on my associate content?
Presumably you have to
So,
have one.
yes, the assumption being, since I'm an associate license holder, I've met all requirements of 301. So one of the biggest differences is, this is one of the issues we've had with APT.
Okay.
Because APT was required to be in a single content area. What this means is that an individual could be an associate English and also history, as long as they've met the testing requirements and all those things.
Would it help brains such as mine to differentiate one as that associate route, so associate educators, and the other being the professional educators? Is there anyone else who would be in bucket 1 other than an associate educator?
Trying to decide the best way to try to explain this, because it gets into some legal issues, and I'm certainly not qualified to talk about those.
But it couldn't just read on line 144, an associate educator or an educator with an associate license may add an endorsement to an existing license area of concentration by meeting the requirements.
I don't believe so, and here's why. We've always, in licensing with, we have these 3 levels, not the associate, but the license area, and endorsement, right? And the practice has always been that a license and a license area require a program. You have to complete a program, whether that's an alternative program, a university program, you have to complete a program. The program recommends you. That's part of the requirements of 301. And so ultimately what this is clarifying is that if I'm already a professional, I don't need a program to add an endorsement. I can simply add that endorsement by meeting the requirements of the rule without any type of recommendation. Maybe that's what's missing from that, is the recommendation part. I certainly understand the problem. I'll see if I can.
Hold that thought. Let's go to Cindy and see if it's different or another issue or same. Go ahead. Board Member Davis.
Some of what I had questions have been resolved, but I'm also wondering at some point if we have any public comment about this.
I know
you'll-
maybe
I know
that we'd
you'll-
like that to inform our discussion. Is that what you're saying?
Yeah.
Okay.
Can I ask one other question?
Sure.
In case there's public comment in regard to it. So another question, similar, trying to find the difference between what's the purpose of maintaining eminence with our current LEA-specific licensing?
So, to be honest, is it necessary? No.
And I thought that was one of the talking points for, this is going to just streamline our licensing.
The intention is that the design of the system is intended that LEA-specific licenses are very streamlined for their first issuance. It is at the time of renewal that they have to be reviewed by the state board. It's my hope, as the person I didn't start this thing, but I've kind of had to take ownership of it as we try to develop this, that in order for the board to be able to meaningfully scrutinize those kinds of requests, there can't be 4,000 of them. Right? One of the issues with letters of authorization is that there's so many, it's literally impossible for the board to closely scrutinize. So what the eminence is intending to do is to give an opportunity to the board to say, these particular situations, we're okay with those long term. And what that does is it reduces the number of LEA-specific renewals that the board is scrutinizing, and therefore allows them more scrutiny of those particular requests. That was the intent.
How many eminence I'm not even sure what they're called exactly, eminence,
The expanded ones that we currently do?
or total eminence, expanded or regular eminence, how many?
I'm afraid I don't have that off the top
I
of my
mean, are
head.
there like 800, or there 8, or there?
Several hundred.
Several hundred, okay. All right, is there any public comment on this issue? Wishful thinking? Not, it doesn't, as, there's not a lot of people and they're looking really uncomfortable. So, sorry, Cindy. I had the same question about, I thought that eminence went away. You promised me that eminence was gonna go away, and I was
sorry.
sort of persuaded that, okay, if all these little kind of exceptions went away, I could maybe live with this licensing structure. This is making me feel like you took away my level 3 license, and it's not really getting streamlined at all. And I'm not feeling a lot of love. Well, feels like it's license creep.
The best I can
Exception
offer,
creep.
the best I can offer is that we know that letters of authorization in the current system, most of them don't require more than 3. The hope in the new system is that most LEA specifics won't require more than 3. The section.
More than 3,
Years, sorry, like 3 years.
oh, to have them become.
Associate or professional.
Like
and-
really pretend licensed instead of.
I'm not going to respond to that one.
Solely
But,
pretend licensed.
but the provision in this rule does allow the superintendent to scrutinize those things more closely. So if I have an individual who, they say, we believe this person is eminently qualified, and, my staff or Sid say, no, we don't think that's good enough, they would have to appeal to you to do that, but that allows us to be more scrutinizing of those.
I don't really have a hang-up about eminence.
Okay.
I have a
Okay.
hang-up about, so are these things that were supposed to go away and they somehow aren't, but.
I apologize if I baited and switched.
Yeah, kind of a bait and switch. Did anyone else have other thoughts about this or concerns? Board Member Davis.
What is the
There's two exact changes. You want to repeat those again, Travis?
So, well, there's only one.
I thought there were two.
There's two. The 2 extensions are eminence and state-approved endorsement plans. The one primary change
I'm
is
sorry.
line 120, where it talks about, district personnel don't need at the state level a specific license. If they want to require it at the local level, they can, but we wouldn't require it at the state level.
Okay.
Okay.
All right.
Anybody else have any other? I had one other concern, and it's on line 149, where it says, the significant number of content knowledge competencies feels very, I'm good with reasonable and stuff like that, but
To be
this
honest with
felt
you,
very
I
uncertain.
went through a number of adjectives, and that's the one I ended on. If you have a preferred
Are you
adjective.
meaning, but I guess I'm just trying to, do you mean 2 or 3? Are you really meaning it, Matt? It depends on the.
I think it was intended to
Area?
mean it depends on the area, because the current rule says 9 credit hours, right? The current rule is very specific to credits, and so we were trying to get away from that. And so I was leaving it vague so that we could kind of, the superintendent would then have to define it for each endorsement. But if you have a better word than significant.
Just criteria. Because it hasn't been defined yet, right?
Would it be accurate to say by meeting a significant number of content knowledge competencies as determined by the state superintendent for each license area? Is that what you're trying to say?
Maybe.
Okay.
Can I
Board
ask
member
a question that,
comments? Sure.
in same line of thought, is my understanding of the associate license is that it creates a program around that teacher, right? And that's what we just
It
talked about.
creates a what?
A program of some kind,
okay,
right? And
right.
so the LEA often establishes what that program looks like based on the need of that teacher. And so wouldn't that same opportunity be available to this professional educator to meet those competencies based on a conversation with their LEA on what is it that you feel like you need in this area in order to prepare you to pass that content knowledge test.
So it's more as determined by the LEA?
Right, so then it wouldn't be the superintendent, because the superintendent is, content knowledge competencies are established how? I'm guessing by the test that's established, right? That's where you establish
So
competencies?
the content knowledge competencies typically refer to the current endorsement requirements, the courses and various the things that are required for specific endorsements.
So are we maintaining those same course requirements for endorsements?
So in the immediate implementation of this, yes. Over time, we need to change that to competencies.
But it says a significant number of content knowledge competencies.
Well, and a course is a way of demonstrating a competency.
Right.
And so we're using the language of competency throughout these rules so that as we transition the endorsement requirements to that, we don't need to.
But even now, someone could come to you and say, sorry, Brittany.
You're okay.
Someone could come to you and say, this doesn't say it has to be
No. So if,
course hours.
and the idea is if they can say, if we have the course requirement X and they say, here's how I have the competencies equivalent to that, then that would be, we would be able to do that.
Okay, go ahead.
Yeah, so that leads to my next question is so the courses are meant to prepare them for that content knowledge test. If they can pass the content knowledge test, why do we require the courses in the beginning?
So the tests are not comprehensive.
Okay.
I mean, I mentioned the history one because the history test is so broad, but ultimately, for example, quite frankly, and I've said this before, the math test, the test that's required for math teachers, if you can't pass that after taking Calculus 1, then you haven't done it. You shouldn't need anything beyond Calculus 1 to pass that test. But that test is not comprehensive of all the competencies that are necessary to be an effective math teacher. That's why the current model has always been the test and the competencies. APT shifted that model to just the test. This is shifting it back to competencies and the test as two different points of verification, if you will.
Okay, follow up on one last thing. So is the intent that as we look at the endorsement requirements for each of these, that it would be more competency-based so that a teacher wouldn't necessarily have to take a course but could show competency in certain content areas and then take the test? Or would be getting rid of the test because I showed competency in all these areas?
Ultimately, long-term, I think we would still include both because the test is an independent verifier of other aspects. But yes, so if, right now, the math endorsement requires Calculus 1, but the goal is to have that say, you need to understand differentiation, you need to understand integrals, you need to understand how it relates to physics, those kind of can-do statements in our student standards, and then a person could demonstrate that without necessarily taking Calculus 1. That's the idea.
Question two.
Cindy?
In line 150, where it says content knowledge competencies established by the superintendent, is the superintendent synonymous with SEA in this case? Like, will the board have any say in what these competencies are? Because these are potential, right? We haven't designed the competencies yet, correct?
I think I'm sorry, Travis, go ahead.
I was simply going to say, in terms of legal terms, the term superintendent in a board rule refers to superintendent or staff. And so it wouldn't be, individual endorsement requirements would not be established or reviewed by the board unless you wanted to change practice. They're currently not in the form of competencies, but there are current endorsement requirements that we would say those are the current competencies.
And then, was the previous concern the words significant number of content because
That
it was
was
so
my
vague? Because I would like to make a wording, and I don't know if I need to make a motion or if this could just be a technical change that people are okay with, but on those same lines, line 148 to line 150, it would say, may meet the content knowledge requirements for an associate endorsement by meeting competency criteria established by the superintendent. Then they could determine which percentage of these equals passing and what that whole program is going to look like in the future.
I think we could make that work.
As opposed to people reading the rule and going, well, what does that mean? Is that 6 out of 10? And what are the 10 and what are the 6?
I think it's a little less, your language is a little less obvious than significant number, but I think it still kind of leaves the same ambiguity, and I guess.
Well, just because we haven't done it yet.
And I'm convinced that it's necessary, is what I was going to say. I'm not thrilled about rules that are that ambiguous.
Can I make a
but-
proposal?
Sure.
Would it be all right if we prepared some language for Board Member Davis that when the rule comes back to the full board, she could utilize that language if she wanted to propose an amendment at that time, and we'd have language similar to what you
It
described?
might be a little more refined or specific.
Exactly, because it's a good idea. I can see where you're going with it.
Do you feel okay about that, Board Member
I'm
Davis?
fine with it, and if this whole group says it's not significant enough to even warrant that, I'm okay with that too, but I just don't want to hit this conversation again for 30 minutes when we get to the full board, because
Same.
nobody can know
Can define
what the percentage is of significant.
Let's do this. Let's do this. Let's consider this amendment right now, and then if Travis if Travis would still work on something
Absolutely.
that felt stronger to us, that then, and you wanted to do it, then the amendment could be made before the board. So the motion before us is to have on lines 148 of R277 309, subsection 2, it would say, don't turn off right now, computer. And starting at the end of line 48, endorsement by meeting competency, say that again, Cindy, by meeting
Criteria established by the superintendent.
competency criteria established by, and so we delete a
That's what he
significant
said.
number of content knowledge.
Something like that,
But
I
it
don't
would, but I would probably want to say by meeting content knowledge criteria, right?
It says that in the beginning, may meet the content knowledge requirements for an associate
Oh,
endorsement by meeting
by means-
competency criteria established by the
Established by the
superintendent.
superintendent.
Or whatever you find that's better.
Right.
I don't know that I can make it better than that.
Well,
if
let's
that's-
go with that, and I'll try it one more time. So it'd be amended to say, by meeting competency criteria established by the superintendent under subsection 277-301, et cetera, and delete those unnecessary words in there. So any further?
You want to leave the section reference though?
There's good and bad things about that.
Because that kind of takes away that goes to what you were just telling me, that takes away the effect of the subparagraph, because then you're basically requiring them to meet all the criteria that they would have had to meet anyway.
I would recommend removing the reference.
So then it would read, by meeting the competency criteria
Established by the superintendent.
established by the superintendent, period. That feels more ambiguous.
It is, because it's delegating it to the superintendent.
Right.
Well, doesn't this
It's already kind of delegated in
Do
that
that
other section
anyway?
too. Yeah.
Which means it's back in your lap. I've worked enough with educators in this area to be frustrated that it is, and no offense, Travis, but
No,
it's kind
I
of
get it.
personality driven sometimes.
I get it.
And I know that's been frustrating for individuals I've worked with, and I'm reluctant to further that, not improve upon it. But I don't have any better language right now.
I won't have any better language, but one of the things I could suggest is that we're coming back into these rules to revise them, as we round up. One of the things that we've thought about doing, even if we don't bring the specific requirements for every single endorsement to the board, rather establishing the process, kind of like we have the process for establishing student standards, that we add into the rules that the superintendent will establish them using this process. And so that we don't have personalities, that we have content committees that are working on these things and that kind of assurance. And I'd be happy to add that kind of language into as we bring things back.
Right, in the interest of getting something moving, let's consider the amendment as just proposed. And then if you have an opportunity or to bring better language to us for the January board meeting, we'll propose that. So it'll go a significant, the proposed amendment is a significant number of the content, knowledge, competencies established, I didn't say that right, by meeting competency criteria, there are
Established.
C words, established by the superintendent, period, would be, yes. Board Member Davis.
So I just want to clarify something, if we need to include this in this particular meeting. If we take this thought or idea, which I think is very, very good, by having a consistent, replicable, every time I say that I trip up, process for establishing these criteria are going to be a big deal. I mean, teachers are going to have a lot to say about this. So I think that the process should be outlined, it should be published, and if our public has a frustration with one competency or something, there should be an opportunity to appeal. So do we need to incorporate that into this, or is this a whole, does that need to be added into this particular rule, the process piece?
That would go in 301, wouldn't it?
Yeah, it would go into 301, and I believe that staff would have, as long as there's no objections to the committee, I think we could accept that as directive that's been
Direction
made,
to-
and we can do that.
To put
I-
that
no,
information into 301.
I don't think we need a motion or anything
And bring
on
it
that.
back to us
Yep.
maybe next month.
Well, it won't be next month, because we're trying to get the license renewal rule.
Okay.
And then once we've got them all done, that's when we bring everything back, and here's the cleanup stuff, and
Okay,
it would be
but
part of
you'll
that.
make a note of it somewhere so it won't
Absolutely.
be forgotten.
I
Because
have extensive
I,
notes.
just to add a little more, fuel to the fire, the concerns I hear from teachers are not about licensing, they're about the endorsement process. And
Let's just say
that's-
that a lot of people disagree as to what it truly takes to be a teacher in a particular area.
Yes, that it's said differently, yes.
And getting that to a consensus is not
It's
easy.
been hard, and like I said, to teachers, it feels pretty arbitrary. And that's something I'd hope we could change. So with all that direction, we have the amendment before us. Do I need to repeat it again? Everybody's clear what it is. I probably can't get all those C words in there. All in favor? Aye. And it's unanimous. Thank you. Thanks, Travis. Thanks, Ben.
We need a motion on the rule.
Oh,
As
now
amended.
we'll have as amended. So can I have, I'll just, go ahead, Brittany, make the motion.
I move that we approve R277-309, Draft 2 as amended on first reading and give to the board for approval on second, final reading.
The motion is that R277-309 is approved by the committee on first reading and sent to the board for final approval on second reading as amended, Draft 2. All in favor?
Aye.
Aye. Now, thank you very much. Oh, last, if our brains are not completely mush. We get to continue our discussion of third-party contracted services. And we have, this time though, which I think is going to be helpful, we have some more concrete, I don't know that they're set in concrete, but we have some more concrete ideas. Angie's going to talk about, she has some assistance from some of the procurement folks and the other people in the office. So Angie.
Yeah, and you may want to just ask Zach to join us from the
Please.
beginning, because even some of the issues related to the first part are procurement related, so. All right, so you all remember, back in October, we received a report and document from our internal audit staff of some risks related to school districts and charter schools that contract with external providers. And during that conversation, the committee asked a number of questions, and I've got answers to some of them. Assistant Superintendent Leah Voorhees plans, and I can talk about this later, but one of the questions was about resources for monitoring staff and what they thought could be helpful by way of supporting, I guess, compliance or what do they need? And she's prepared to come back in January if you want to have kind of a part 2 of this discussion about monitoring staff's perspective and do they have what they need was kind of the question. But today we'll talk about the questions that I have listed in the memo that's there on board docs.
So that's maybe where we should start
I mean
first,
civic
is-
clerk, yes. So
Okay.
I've got that up there. And the first question was, what do other states do with respect to monitoring or overseeing external providers or third parties? And so you can see that I reached out to ECS, that's the Education Commission of the States. They have research teams and they do this research for us for free, which is so wonderful. And they have this good access to what's going on in other states. And although the document says something about 24 hours, it was not a 24-hour request. I asked them way in advance, but I think what they're trying to do with that disclaimer is say this was a quick research project, so just keep that in mind. So the first thing that was interesting, you'll see that the researcher or the policy analyst found that not a lot of states have comprehensive or requirements in state code about monitoring external providers of school districts. It's right now, most of the provisions are related specifically to charter schools. And if you look at the 3 sections of code that they provided as examples, all 3 of them require authorizers to include these things in the charter agreement, or they require the authorizer to review these things before granting a charter. So it's helpful. But it's interesting to me that the approach has been more about including this in a charter agreement or having an authorizer review this before they open the charter school. So I guess I would start there because as you probably saw in the memo, they said generally with respect to school districts or local school districts, they've just allowed, that's been more of a local control issue. Now
Well, they still have to follow procurement code.
They still have to follow
right?
procurement
It's
code,
just not
correct.
in the
And-
contract in the inception.
Right. Well, and that might be part of it, is that oftentimes with charter schools, some of these contracts are entered into before the school even becomes a charter.
It hasn't
Whereas you're correct,
been chartered yet.
a contract with an external provider by a district, it's going to be subject to procurement. Generally, there are different conflicts laws that apply to local school boards and district officials versus charter schools have very different conflicts law in Utah. And then I think the point that you just made, some of these contracts are entered into pre-procurement. So regardless, I mostly didn't want to make this about charter schools because I don't think that's what our discussion in October was about. It wasn't about charter schools. I think I'll just give the qualification that sometimes charter schools have been brought up in these instances, maybe because they might contract out for a larger percentage of their services than districts, although I don't know that's always the case, because I think districts are starting to use external providers more and more. But charter schools probably started that practice a little earlier and do it at a larger scale. That's all I'll say.
Well, and just
Right?
to interject, because charters don't have district offices,
Right.
that even the smallest school districts have.
Yeah, that's a
Okay.
fair point, too. They might be contracting out because they don't have the economies of scale. So with that, I don't know if you had an opportunity to look at the sections of code. I provided those sections. I pulled them out in a separate document. But then actually today, just to make it even more visually easy, I just thought I could quickly go over some of the elements that were in those 3 state statutes. And these are just kind of a short summary. But you can see that all 3 of them include a requirement that the providers show that they have success supporting other schools, including demonstrating with the academic achievement of their students, as well as the evidence of successful management if available. And you can see other things here like performance evaluation measurement, a copy of the contract, the scope of the contract, duration, compensation structure, so identification of proposed fees and amounts to be paid by the provider, conditions for renewal or termination of the contract, a conflicts disclosure. One thing that was interesting, Indiana requires that the legal counsel for the school and the provider cannot be the same. So it's essentially saying before the school enters into a contract with a provider, they have to make sure they each have their own legal counsel. Then a couple of those at the end only apply to one state. So disclosure by the provider of actions taken against a school that they served before. Student performance data, financial reports of all current and past charter schools served, and then in Maine, an explanation of how and why the provider was selected. And so I raise these because in a lot of ways, some of these elements relate to procurement. It could be that, I mean, there's ways you could potentially incorporate these not in a charter agreement, but instead require LEAs that contract with third-party providers to do some of these things before they contract. You could require that, we could change procurement code or require, as part of the procurement process of the RFP, that they include some of these elements. So I thought those were interesting. I don't know if you want me to pause and then we can discuss, or, anyway.
Yeah, this is kind of even more overwhelming than I thought, having looked and talked. Board Member Cummins.
Did you look at how many of these things are currently not in procurement code?
In our procurement
Yeah,
code?
Utah's.
That's a good
Because
question.
some of them, I think, are like already required in code. Is that correct?
Uh,
Would you like me to?
yes, please
For the
respond. I'm
initial
sorry.
authorization.
This is,
So Zach Christensen, Director of Purchasing and Contracts for USBE. A lot of these things are not in the procurement code laid out, kind of as they've been explained here. There are certain things that are very similar, for example, with the school turnaround in the statute that describes how we have to contract, or the school districts have to contract for those services. A lot of these are similar to those items that are in that legislation already. We do have, as best practice, a lot of these as far as like the scope of the contract duration, those all have to be in the contract. However, these other things are not necessarily provided in.
And I guess even if you had them in the procurement code, an issue would be right now, LEAs are subject to procurement law, but I don't know that anybody is actively out there kind of monitoring whether those procurement, whether that process is being followed
pretty well
and,
tell you
and,
they're
and
not.
auditing those contracts to see if, as they did the RFP, did they ensure all of this? So, anyway.
Cindy, did you have an additional question?
That was my exact same question, is how these juxtapose with Utah code currently.
In procurement, in our procurement. code.
In procurement, yes, and in particular, before entering into any types of. And also with authorization, if we do authorize a new charter, are some of these provisions, because this procurement question was brought up by Deputy Treasurer several times.
Kurt's Law.
Kurt, yeah.
Oh,
So I'm just wondering if we have anything currently with the authorization process.
No.
in
None of it-
authorization.
With like something that our authorizers are looking at before they open a charter school.
I don't think we do, because we talked about this a lot.
Jennifer, do you want to
Jennifer,
respond to that just quickly? I think I don't think we need a long explanation, but.
In Section 8 of our application, we do ask for, if they have contracted with any CMOs, that they include information about that as well as the contracts.
And so that would be the scope, the contract, copy of the contract, you could see the scope of the contract, you could see the duration of the contract. You wouldn't necessarily see the compensation structure. You probably would see the conditions for renewal, probably not conflicts disclosure.
Does it have conflicts of interest disclosure in it?
So first off, I would have to go back and look exactly at Section 8. I'm not the staff that oversees this, of what exactly we ask for and include, but we are asking for the information. I know that on facility reviews, we do ask for that kind of information. I would I would have to go look exactly if we asked for that in our application on the CMOs, but I would imagine it would also come out because we asked for background information sheets for each board member in the application as well that would list associations.
So how, if the proposed charter doesn't provide it, what do you, you throw out the application? Do you say, oh, please provide it? Do you say, we're not going to even further review this until you do provide it? What's the?
So most often, schools do not contract with a CMO until after they are approved. So we only get that if they have a memo of understanding or a contract with a third-party provider before they are approved.
And then if that's the case, then you don't look at any of this because the contract was with a non-governmental entity, is that right?
So our conversations in the application process would be asking them, like, if they tell us, well, we'll just fix that by contracting with someone, will we take that into consideration in the application? And we drill them on how they're going to be able to fulfill their duties. But if they have a charter and then they choose to contract with a curriculum provider or someone to provide services after the fact, as long as they're doing it within state law, board rule, the charter agreement, they have that local control to be able to contract with who they need to be able to carry out their duties.
I think I'm not asking the question right. I'm saying if the entity, the proposed charter school entity, contracts with the CMO before it comes to you to get its charter, then you would not require this stuff of that proposed charter school, would you?
Just the opposite. If they contract with a CMO before they are approved, then yes, we are, and I would have to go through exactly of what we are requesting.
Not holding you to every single one.
But we do ask for the information, including the contract, so that we can review and we know what we are approving.
But I never got the answer on, so if it's not provided, like if there's not a conflicts document provided, disclosure provided, what do you do?
So are you asking in the case where a school basically misrepresents, where they did contract with someone, but they do not provide that information at the time of the application?
Yeah, and I don't mean it necessarily misrepresents, it just forgets or it
Right.
overlooks it or something.
Well, if their application is incomplete, we do not process it.
You just don't process it, period.
But that's the hard thing. If they don't provide, if they're saying that, no, we haven't contracted with the CMO, so they don't provide us the information, we assume that they have not contracted with the CMO. We have never run up against a case where we have found that someone should have provided us this contract and then didn't.
Okay, that's helpful to me. Cindy, did you have was that?
If I understand what I've learned over the last several weeks, you correct me if I'm wrong, is that, our charters are following the same procurement codes as district schools. It's the concern that the treasurer's office brought up was just that initial, when it's a 501c3, could contract with any company without going through procurement laws because they're a 501c3 and they haven't yet been authorized. And so I think there was some conversation, and one of the recommendations I think from the task force was to look at that in how to maybe have those procurement responsibilities come earlier on as part of a condition for authorizing later.
But what I heard, let me just make sure, what I heard Jennifer say is that if that's the case, then in the application to become a charter school, the charter board asks for the information in order to be approved as a charter school that may have gone before being a charter school. But they don't, but that doesn't mean they comply with procurement.
That doesn't mean that it's in the law that they need to follow procurement
That's right.
code to
It
do
doesn't mean that they didn't choose their brother-in-law. All they would do is give you the contract and et cetera.
But they,
Brittany,
but they could say, in order to be authorized, you must provide these types of documentation. So it's not like, if it's known that I'm going to have to show this documentation at the point of authorization, I'm not going to want to go into a contract and risk not being authorized at that point. And so I think as long as it's very open and apparent what is going to be required at that point of authorization, then I think the risk is minimized.
Okay, that's helpful, thank you. I'm still kind of feeling like, if this is required by the charter board, how does it not happen? Go ahead.
I'm trying to think, it's a relatively new requirement. I do not know that this has happened for years. I think maybe in the last 6 or 7 years. I would have to go back on the applications, but I do not believe that this has been throughout the entire time.
But it's been, you think, that long? It's been, and I'm not holding you to the exact, you're thinking for the last 5 years, perhaps?
I'm trying to think, because I believe it was my predecessor who put it in. And so it's been for longer than I've been here as the director.
Thank you.
Just to
Cindy?
clarify, it's that they provide information, but it's not that following procurement code, even as a 501c3 prior to authorization, is conditional to becoming authorized.
Correct. We do not tell them that they have to follow procurement code because they're not yet, but we do, we're going to take that into account. If there's something that smells fishy and does not look appropriate, that is going to be considered.
Brittany?
Maybe a possible actionable piece from this information could be, because we recognize that the State Charter School Board has pretty much kind of been our model authorizer as we've gone through the rules of what the authorizing process should look like. But we know that they're not the only authorizer. And so we added into rules some of those things that the State Charter School Board had developed over things that they'd learned over the last several years. Could this be something that we add to that rule of the authorization process? Maybe, I'm not pointing to this like this is it, but some documentation, contract documentations for charter schools who are authorized or who enter into a contract prior to authorization. Here is the documentation that must be provided at the point of authorization. So, and I don't know that it needs to go to this extent, but some general contract transparency information that says, okay, here's some disclosures of conflicts of interest, here's the copy of our contract, et cetera. Those most important pieces maybe based on what you guys are currently doing, and recognize that would be best practice for all authorizers, that before authorization, here's the documentation that must be provided about contracts that were entered into during that 501c3 moment.
So I think, just to make sure I'm understanding what you're saying, is taking what they have or building on what you have in your application process and putting it to board rules. Is that what you're proposing?
Correct. So that we have a board rule that kind of talks about how the authorization process. It's not the application that's in board rule, but here's the basic skeleton of what needs to happen, right? Tell me if I'm misrepresenting this. Yeah. So it could be in there, just those basics, says, okay, prior to authorization, here is prior contract information that must be submitted, et cetera, and using what the State Charter School Board has established as kind of that minimum.
And one of those could even be verification that the 501c3 had some kind of a procurement process? Do you want to be
Maybe the
that?
state procurement process, they followed that.
Well, yeah, I don't know if the 501, I guess they could follow, I guess it could be required to follow the.
They could if they want to be authorized.
I don't know that it's necessary to require procurement process, but if you require documentation, then it says, okay, there needs to be a basic amount of documentation to prove that, here is how we can prove that we're not doing anything nefarious here, et cetera. But just because if we start requiring code on someone that isn't our authorization to require that code to fill that.
That's what I was getting at. I was saying that you could require them to demonstrate how the proposed charter school procured whatever the issue is.
Correct, so so it's here's the things that we need you to show that you did,
Okay.
or you're able to show them.
Does that feel kind of good? We're not.
If those things kind of match similarly to what we require in procurement code, if it's just show us how you got your contract, it's really not that much different than
with
what
your
we're doing right
brother-in-law.
now.
If
I
it's-
mean,
yeah.
the point was that there's a more kind of strident procurement code, and you cannot legislate that a 501c3 has to do this because we have no oversight over a 501c3, but you can use it as a criteria to become
Right.
authorized to start to receive government funds.
Are you too clear about what we're getting at, or
Mostly.
Angie?
I do have a question, though. And it is getting this information, is that all that's sufficient? What if they get information or they see a contract, but there is something fishy, right? Or the fishiness, I'm just going to use that
It's
word.
all right, it works.
Happens after the charter school has been approved, but before operation. I guess I'm wondering what the second step is. On one hand, we're saying, give us all this information, but if they give them the information, does the authorizer have the authority to say, okay, now, sorry, we're just going to pause and we're going to say no? Because
We don't like how we don't like how you procured your.
Yeah,
We're
I don't
getting
know.
the weeds.
So can I,
Okay, Brittany first, and then Cindy, and then to Jennifer.
I feel like
Go
we're
ahead.
confusing two issues, right? Because procurement itself does not exclude one from fishiness, right?
Yep.
Well, it helps. It helps a lot.
And so I think it's being very conscientious that just because you follow a certain procurement process doesn't guarantee that all fishiness is out of the water, right? So.
To continue the metaphor.
And so I think it's just being really conscientious that, that here's a 501c3 and they have the right to enter into a contract and they have the ability to do so. But they don't have the automatic right to receive a charter or receive authorization to begin a school and to begin that function. And so what is the criteria that you want to establish that says if you would like to enter into contract with the state and be given authorization to
Be a charter
be a
school.
charter school, then here's the criteria that we'd like to look at, and please show us all the documentation that you have, because otherwise, we can't assume fishiness in any given scenario, but we can ask for certain criteria to be met in order to avoid things that could have been shown if it was like a very transparent process. Like, yep, here's our contract, here's how we entered into this contract, here's who was involved in the process, et cetera.
Cindy.
I mean, I feel like we're kind of saying the same thing. I'm just saying there's already a wisdom procurement process created by law that could be that criteria that is
Well,
asked for
and-
for
and
authorizing. But I think we're getting too much into the weeds at this point. I think we should finish hearing, the research that you have and then figure out where we want to go from. Do we want to start getting into specifics like this? Or do we
Thank you
want to
for helping me with my job.
have our folks come back and juxtapose what we truly have juxtaposed to what some other states are doing that have found helpful or not, or?
Yeah. I think we've got the idea of this, and, yeah, so did you have something
I
to
have
add?
to add, so for understanding of the two most common situations that we see for this. So first off, that we usually see most often if they are bringing a contract to us at the application stage, like they've already gone with someone, that it isn't so much a procurement process that they would go through. It's usually that this is their curriculum provider. This is the school that they are. So it might be, I'm trying to think, well, we have like some of our online schools where they are from a national provider, that is their school. And so it would just be jumping through hoops to require a procurement process. It's not in choosing that entity to go with them, that is their school. If they didn't have that
we got
entity or
it.
that CMO, okay. So then the second most common, if they're truly gonna go through like a procurement process, they usually don't do that before the application stage, because I think the perception is that makes it harder for them to get approved. And so it usually is after they are approved that they are going into the procurement. And then it goes to what Angie's addressed of, well, what if they do that but poorly afterwards, we really don't have a step or anything to intervene there. So those are the two most common that you're going to see.
So can we go ahead and then let's kind of.
So
hold
I think these are
thoughts and-
important pieces of that puzzle to look at when we come back and do at some point maybe get into the weeds, I don't know. I think those are important caveats to think about. And then I think it's important to think about the one thing that was brought up earlier is that if a management company kind of recruits a board and then the board, it's understood, is going to use
Uses
that
that
management company.
company.
So there's a piece, is there something that we could incorporate with procurement that could help with that other scenario? And so again, I don't think this is a conversation to get all, right now, because we've been talking about this for 30 hours in the charter task force and haven't solved all those problems. But it just some things to pieces of the puzzle to keep in mind
And
as
kind
we
of,
move
and
forward.
I was thinking, just to talk about trying to move us into the rest of this, is I was thinking that these kinds of things would be put in rule that then the charter board or the authorizer would have to look at to say, I don't know, I'm making,
Establish criteria.
maybe these things have to be in place for you to be approved as a charter school. And if you haven't done it this way, we're not going to approve you as a charter school, and let them go back and clean it up. I'm just thinking out loud. I'm not determined that that has to be the way it is, but that was kind of my vision. But I agree. Let's hear the rest of this, and then, because what we want to do is take some of this information and then tell the staff what we like best is this kind of basic direction with a few pieces, maybe some pieces of others. So go ahead.
All right, and before we get to the next question, I'll just go through the rest of this research.
Yeah.
I think the report that you can see, there was an Office of Inspector General audit done in 2016, and a lot of the audit findings were kind of similar to the issues that our auditors brought up, which is oftentimes, the more you contract out with external providers, there's a risk, because what if they just up and leave, or they don't provide you the information? They talked about how some state laws and some contracts don't give a lot of authority or power to the actual school, that it tends to be that sometimes it's the external provider that's managing the school versus the other way around. So I think we're all kind of familiar with some of those issues that can happen, and it's in a lot of ways just supported what our audit team presented in October. And then you could see in the research that ECS provided some models like turnaround and student data privacy and textbooks where states have provided more direction. I think we have a lot of direction in our student data privacy laws, and I know our student data privacy team has model terms and conditions. They aren't required by statute to use them, but because we've provided them and we have the consortium, I can't remember the name of it, but we have a tool essentially at the state level where LEAs can see student data privacy contracts with third-party providers, and that's been a helpful thing for our school districts and charters to comply with student data privacy laws. So that's an example, and it's an area that we've already done that. I know Zach has worked a lot with Whitney on those terms and conditions. And then I think Zach already alluded to the fact that our turnaround laws and provide kind of some more guidance on what those contracts and the providers in those areas, they have to actually be selected as providers, meaning they have to make a list before an LEA can contract with them. So it's almost like a Better Business Bureau. I don't know. It's a vetted list of providers, and in order to get on that list, you have to show success, and you have to. There's more vetting of those providers before LEAs can contract with them. So should we move to the other questions?
Just a quick question, how
Yeah.
do you ever become a provider if you have to show you've already had success? That would limit the market to only those who have already done it.
I guess that's the question is, do we want, and in turnaround, I think what we've shown is we don't want people coming in consulting schools on how to turn around a school unless they have that experience turning around a school. But I get your
So
point.
that's gonna only be for turnaround?
Well, that's just the way it is right now.
She's talking about a model. And I think it would be possible you could have you could say, if you can't show success, then you have to demonstrate what you would do, or maybe success in a related experience or something like that.
So one thing, I actually asked ECS to look into Georgia's model and how they vet providers of SIS systems, but for some reason they didn't include in their research. But when I sent my request, I said, I'm aware of Georgia. So Georgia, for their student information systems providers, Georgia's education agency does a similar thing with turnaround, where you can't run like Power School or Skyward or, those systems. You have to make it onto an approved vendor list before an LEA. So an LEA may not contract with a student information systems provider in that state unless they've made it onto the SEA's list. And the SEA, the Department of Education, has a real tight relationship with those vendors, meaning they train the vendors provide feedback to the Department of Education. So I guess that's another, I'm not saying that I don't know that we as a state are ready to have the State Board of Education do a
That sounds worse. I don't.
but it works for them versus having an end-to-end system. What they've done is they have this relationship with their student information system providers, so they still have quite a few, but then the student information system providers are really responsive. You don't have districts or charters entering into agreements with providers that can't essentially perform. I mean, it's kind of like what happened with us with Questar, right?
But the problem is, well,
Anyway.
we need to move on, but.
So that's it on that one.
It's kind of it's kind of like a, it's a closed system, but I feel like it kind of has a different set of problems that anyway. Okay, why don't you tell us some more, and then I want to get to because we want to give them some direction so they can come back with some proposal for us. So try to keep all of this in your head at once. So this is the information from ECS.
No, now this is so the ECS stuff, that was it. Oh, there was one more thing. I apologize, and I'll stop talking. It's hard because there's a lot of information here. But one other thing that ECS provided was this resource guide from the Colorado Department of Education, which it's essentially guidance for LEAs on how they work with, contract with, or engage with external service providers. So that was that's something that's not legally binding. It's a resource.
Guidance.
It's guidance. So now we're back. Now, if that's the ECS document, do you want to move to question number 2, which is why Zach is here?
Yeah, and the question number 2, just so I don't have to go back to that document, was?
It's, are procurement rules being followed, and are there any policies related to procurement that could be amended?
What should we do about procurement is kind of the gist of it, right?
Sort of. The next one kind of is related to
All right,
procurement too.
Zach, why don't talk about procurement for a while. And the more I think about this, I'm not so excited about this possibility, but go ahead, let's talk about it.
Okay, so with procurement, all of the LEAs and charter schools are required to follow the procurement code and R33 for their administrative rules regarding that. R33 is set by the Procurement Policy Board, and that is not done by the Board of Education. Unfortunately, some of the issues that we see is we have no oversight or enforcement ability to make sure that any of the school districts, LEAs, or charter schools actually comply with this. We can offer training, which we offer to anyone, but as far as actually going in and monitoring, auditing, or making sure that things happen, we have no ability to do so from the procurement code standpoint. So we can just say, good luck, and if you have questions, please call us. If they have the option, or they want additional help, under the procurement code, they can enter into a contract with the state Division of Purchasing to have them become the procurement office for those individual schools. So that's kind of the current status of where things are with regard to the procurement code, and that is because when we became an educational procurement unit a couple of years ago, we were subject to state purchasing as well. So all of our purchasing went through state purchasing, but when we became that independent educational procurement unit, we only had ourselves excluded. We didn't have anything to do with the school districts or charter schools follow through with us as far as that rulemaking authority or that ability to contract and assist them with their procurement activities. So that has stayed with the State Division of Purchasing for the current situation.
So I think go to the next step. If we were to say, hey, a lot of the problems are related to procurement, then we could, one of the options would be to do what, Zach?
So some of the different options that we have looked at is, one, we could amend the procurement code to make the board the rulemaking authority for the different LEAs and for the charter schools. That would give the board the ability to provide additional rulemaking authority to say we will require certain terms and conditions for these contracts. You have to do these certain things. We can review contracts for two schools or those that have a certain time frame or other things. We could also require that any of these third-party contracts must also comply with the procurement code because we already have that they must comply with 53E, 53F, and 53G. We could make that additional change as well to hopefully provide a little bit more leverage to make sure that they are following these certain rules. Yes.
Go ahead.
That would be helpful, because what's happening, we're kind of starting to see some things happen where right now our LEAs are supposed to kind of monitor the third-party providers. We're supposed to monitor the LEAs, and we go to the LEAs and ask for the information, and they say, well, we can't get it from our third-party provider. They won't give it to us.
Mm-hmm.
Then it stymies the whole process. So are you feeling like something like more monitoring over the initial contracting in the beginning would mitigate some of those problems on the back end?
I think it can help. And I think if we, and I think what Angie provided as far as like this resource guide, I think that's a great training tool and resources as well. That if we can actually get in and help prevent a lot of these problems at the beginning, it's going to be exponentially easier to make sure that these problems aren't repeated, and some of these schools or school districts are stuck in these bad contracts that they can't get out of. And I think some of that is also if we can say you have to have either these terms and conditions or something comparable. And one of the things that we really appreciate is that our terms and conditions have been vetted through the Attorney General's office. And we do have those provisions like the termination for convenience, termination for cause, that all of our contracts in that are public record, and that we do have that right to go in and audit the vendor, and they have to provide that data and information back to us. If we can start with some of those type of efforts and get these different schools in that, I think that definitely provides a lot more leverage and help in the process.
But here's my hang up about this, and tell me if I'm wrong. Maybe I'm wrong. I'm concerned that, so essentially what you're saying is the procurement unit in this office now becomes the procurement unit for LEAs?
No,
We're not there yet.
No, ma'am. So it would be that the board would become the rulemaking authority for the LEAs or the charter schools.
So we just set the rules for their procurement processes.
Correct.
But then, and then who would decide what if they don't follow them? Who would monitor them to make sure they follow them?
I think at that point we could create new rules that address different monitoring and compliance.
But wouldn't that then kind of, so you aren't exactly the new not the procurement office, but we create rules that require certain things, but how many staff people are you going to have to add to be able to have that be possible?
That's what I was thinking too.
Yeah, I just can't
Correct, yeah.
imagine, I mean, there's a whole state procurement office that writes rules and ostensibly monitors them. Having had experience, they don't monitor them very well, but, okay.
So yeah.
I mean, you would have to have add staff to do that, right?
Correct. If we were going to start monitoring for compliance and that, we would need additional resources. We currently do not have the staff
Right, to
availability
do
for
that. Okay. Okay, go to, and I know some people back there have some ideas or thoughts about that, but some people. But go to the next kind of, I think the next one is what I was proposing originally, or what I thought you were saying, or maybe not. Maybe I'm making that up. Any other questions about what Zach is proposing first? Jenny?
So I'm realizing we need some kind of compliance element. I guess I'm thinking about this a little bit like curriculum too. At what point do we become, I don't know, does it become out of balance? Does that make sense? Where they're not no longer owning it, they're waiting for compliance. In other words, they turn something in and, okay, do I comply? I don't know if that makes any sense. So there has to be a balance to that. I think we could overstep that too, where we're into the local control element instead of into the, does that make sense what I'm saying? I mean, I think we've got to keep it within balance. That's all I'm saying, because we're going to have to hire a whole new department. We're going to have to, you know what I mean? So at what point does that?
Is
Yeah.
the cure worse than the disease? Is that what you're saying?
I think there has to, but I do think there has to be, yes, but I think there has to be an element of accountability, but at what point do we overstep that to where, anyways, I don't know. Yeah.
Brittany, I'm sorry, I wasn't looking in your direction.
I was just going to say Kevin's really excited about the idea of
Coming up.
being this auditor. No. So if we were to step back and not go to this idea
At all.
of taking rulemaking authority over procurement, but look more at training and somebody please remind me, but a few years ago, maybe 4-ish or so, we did some rules and they talked about requirements of contracts with third-party providers.
Was that 4.9? Was that the UHSAA thing?
It was before UHSAA. It was related to student data privacy, but it also included other things that would be required. So if an LEA enters into a contract with a third-party provider,
I think it was student data privacy.
Was it just
Before-
student data privacy?
Well, we have
familiar, Whitney?
115.
That sounds
that's one.
familiar.
Anyways, and so I'm just wondering, so while we may not have procurement authority, what authority do we have to put into rule that says, if you're going to enter into a contract with a third-party provider, here are the requirements that need to be in your contract,
Right.
and it matches the training that we provide. So here's best practices of contract negotiation, and because there's certain areas that are essential, like student privacy protection, data, obviously actual student protection of the, not just their data, but any interactions with students. And so is there a way that, so then it puts the requirement on the LEA, and it has the LEA holding that responsibility, and obviously they would have to be going out and doing their own procurement thing, which we wouldn't monitor, but a good procurement process would end in a quality contract, which could we put into some of those requirements to say a contract should show and use some of those things that were in that
Document.
thing,
Whether
that
it's a
document that was
rule
up
or a-
there.
And
And I don't know if
And
that
let me just
oversteps,
see
so I'm
if
just curious.
This, maybe I'm simple, maybe I'm just wanting you to be saying what I was thinking, but to me, that feels like the rule R277409 that the board passed that required LEAs to, they could only enter an association that agreed to these things.
That's like the
So-
Utah High School
That's what
Activity
I'm
Yes,
saying.
but
Association.
this,
would
what
fit
I'm
into
talking
the
about was
contract.
it was before, and like I said, I have all these
But is the
memories of
concept the
millions of
same? Is
rules.
the concept the same, or how is it different?
Well, so it would be a similar contract. So if you're going to enter into
Or
a contract.
concept, yeah.
So if you're going to, the contract. If you're going to enter into a contract with a third-party provider, you need to be able to show in your contract or to the SEA, to the state board, that your contract contains these
This
things.
term, this
And
term,
I
this
do
term,
believe
this
we
term,
had this conversation around student data privacy, and there was something else that was linked to it. But my question is this an appropriate place to have this conversation, because we don't want it to be too onerous, but we want it to be protective. So the next question is there anything USBE can do to protect LEAs from agreements that aren't favorable to LEAs? Well, here's some training, but also here's what you should have in this contract in order to protect you as an LEA from third-party providers. And I know this conversation keeps coming back to charter schools, but I think some of the risk in charter schools is noviceness in contract negotiations, right? And so how much training and information can we provide to an LEA that says, here is what a good contract looks like, here's how you as a board have the power to negotiate a contract, and here's what you should expect and ask for when you go into these contracts.
Go ahead, Zach.
The State Division of Purchasing does provide quarterly training that is available to all procurement units in the state, where they address a lot of procurement issues and these different concepts. We also have the EdPAC, which is the Education Procurement Advisory Council, that does an annual buyers conference that is geared towards K-12 education, and that's an annual full-day training. But I do agree that I think most of the issues come from the fact that a lot of the people who are working in these different areas, it's only one aspect of their job. They are, their whole purchasing department plus these other things. And they aren't able to attend these trainings, these all-day trainings, and especially if they are in more remote locations, because that will require, a day travel, the training and after.
And then there are those problems, but what I do like about this approach, and maybe we need to refine it or maybe we need to, we need to process it more between what I'm kind of thinking and what you're saying, Brittany, but what I like about the general construct of it is it puts the responsibility on the LEA to say, you're going to contract with another provider, and the state who's giving you money says, in order for us to approve that, you have to demonstrate to us that you did A through L on the issues. And then all we have to do, the state, has to do is say, yes, you satisfactorily did, and provide documentation, you satisfactorily did A through L.
And I would not go that far, because we're not going to approve contracts. And like any other rule that we have in place, there's an expectation that you will follow this rule. And the only way we're going to know that if you're not following this rule is if we send Kevin out.
If we audit. I don't want to increase auditors
No,
any more
I'm
than I
just
want to
kidding.
increase
No,
procurement people.
but when you establish a.
Or attorneys. Be clear.
But the assumption when you write a rule is that this is the expectation. And going back to, Zach's comment earlier, there is lots of training available, but you don't know what you don't know. When you're in a situation, you're just like, well, let's go into this contract, right? And if you trust the vendor, you trust the people around you who don't know what they don't know, et cetera. And so if you have this in rule, then it says, here is what you need to look at in your contract as you go through it. And then it points people, oh, there's this whole world of things in procurement that I should know more about. And it can point to resource guides, because trainings, daily trainings, quarterly, whatever, are impossible for board members to get to at a general level. Number one, you don't know that they're there. And number two, who has time for it? So we have to get the training to boards in their board meetings when they're making procurement decisions, saying, oh, what is it? Oh, let's look up in this guidebook that says, oh, we should be following this process, and here's some things we need to make sure in our contract.
And I guess, and maybe this is leaves room for further discussion, because I feel like we've been doing that for a long time, and a number of LEAs of all varieties have said, we don't have time to do that. We know the rule says we're supposed to do that. No one's ever going to check. We're just going to go quickly through A through L and maybe hit on 3 of those. And so my feeling is we need to maybe limit the list, but where we do have control, where the board does have control, is with the LEAs. And I'm more of a fan of saying you must do, even if it's only A through C. Limit the list then, but require certain things before the LEA contracts and receives the money so that it isn't just this, it isn't aspirational. It's small enough that we can check, and it begins something that's required instead of suggested, because we don't have the compliance on the back end. But I totally am with you on the training.
Can
Go
I
ahead.
clarify? Are you chairing today?
Me or Jack?
Sorry. I'm sorry.
I'm totally
I'm
okay
sorry.
about it.
I didn't imply that there's maybes, but that we create in rules shalls. These shall be in a contract, that you engage in a contract. I'm just saying that we wouldn't be part of the approval process in individual contracts. So we're not. Yeah, the board or the state, here, the board's not going to approve, oh, yes, LEAA, yes, we approved that contract, you went through this process. Because that's what I thought I heard.
It's somehow we've got to have some documentation, I believe, that says, yes, they did it. And I don't know if that involves approving the contract, or if it.
We'll add it to the
or if it
assurances
involves,
document.
one of the examples of here, and assurances we know are kind of hogwash, so no, forgive me, but one of the examples that Angie had was a state that required, oh, now I lost the kernel of this. It wasn't just they required legal counsel from both parties, but it was, no, I thought it was in the narrative somewhere that says that, was it Ohio that required that LEA to demonstrate something? I can't remember. But anyway, maybe we can find middle ground. And we have got exactly 7 minutes. Cindy, so anyway, I would be looking for something that's a little more directive than that, but I hear what you're saying. It's not realistic. I think the charter board has tried and failed to review individual contracts. And that's not fair. Maybe tried a little bit of it. Okay, Cindy, go ahead.
Lisa's, just as we're trying to find this healthy middle ground,
Yeah.
and adding in the shalls and looking at, I do think adding some requirements for contracts can help mitigate some of the problems we're finding on the back end. And I think that we're headed in the right direction with this train of thought. Another piece I think we need to consider is then what happens when our folks go to the LEA and say, we need this information, and the third-party vendor doesn't give the information to the LEA, then what happens?
And that's my point about, hang on one sec, Brittany, but that's my point about you can only contract with an LA who says that the LA will, or with a third-party provider that says it will do that. And if it doesn't, then, you know what? Come up, that LEA, that provider's in breach of contract,
And
change.
get out, exactly, because.
Go ahead.
Because that's the crux of the conversation, is the contract here, right? Establishing an effective contract that says, you must give me, I am the LEA, I'm the one driving the ship here, you must give me information upon request, and you must provide me with what I want, right? And so a good contract puts the LEA in the driver's seat, and that's what we're talking about here, is the contract, not the relationship between an LEA and a third-party provider, because the contract establishes that relationship.
And bless your, go ahead. Well, bless
Follow-up question, follow-up.
Go ahead.
So then if the LEA says, we can't get the information and we're not going to cancel the contract because we like what's happening with this contract, then what happens?
And I don't have the answer to that, but I'm going to even go back even a step further to Brittany's situation. I have been exactly in that situation where it was a good contract and we thought, oh my gosh, this is great. And we've gone to the third-party provider and said, you've got to give us this information, and said, make me. And not only, if you try to make me, I will destroy your data. And that's the problem. You think you have a good contract, but that's why I think that I've got to find some way to put the burden on the LEA.
But if that's the case, there's no solution to this, right? If you're saying, there's no solution to a bad player in this situation. If they're going to destroy your data on your way out of a contract, there is no contract, no procurement code, no any entity that is going to fix that issue.
But if it happened once, but it happens constantly. I don't know, I've got to figure out, I don't know, but I'm not giving up yet either.
I think, Carol, I think you're going to have some bad players. No matter what kind of things we put into place, there are going to be some bad players that none of this is going to fix.
Yeah.
But my question still stands. If we put all of this into place and an LEA doesn't get the information that we need and then says, we like this contract, we're not going to cancel it, do we withhold funds? Like what do we have the authority to then say, you have to cancel that contract? Or where are you seeing that piece fitting in this, if there is one?
So if we are required, so if there is, the only time we go for information, it's in board rule that says an LEA must provide this information, right? If they are not compliant to that board rule, then yes, we can withhold funds. But then it leaves the responsibility on the LEA to have a good contract. If they're like, we can't get our information, but we don't care, right? Then they're not compliant. If they're like, we can't get our information, give us time to fix this, then that's a different story, right?
Because bless your heart, Brittany, they say, no, we won't give it to you. And the LEA is powerless. I mean, they don't have the money to go into court and enforce that contract in court, which is the next step.
So they can't get out of a contract?
They sometimes have to breach. I mean, I would say in legal terms, the third-party provider has breached the contract. But there's not an automatic fix to it. They have to go to court and say, this party, you have to file a civil lawsuit that says this party has breached the contract. And the court doesn't usually order specific compliance, or instead it says third-party provider, if it does anything at all after like a 6-month, $10,000, $15,000 expenditure, it says you have to pay this vendor or this LEA for some bad act that you did, and it doesn't really address the problem. Try.
Okay. In those cases, we do have certain remedies under the procurement code. If a vendor is refusing to perform under a contract, we can move to suspend or debar them, which means that they would be placed on the federal
which is
debarment list, and
kind of
they
an
would not
effective
be eligible to receive state or federal funds.
Or for other entities to
Yeah,
contract with.
contract with.
So are we saying we haven't done that to this point when our folks have trouble getting the information they need because we haven't taken the steps in the beginning to require it in the contract in the beginning? Is that why we haven't acted on this opportunity that we have to act on, or have we acted on?
In that case, we have no
The board doesn't have
ground
the
or
authority
standing
right
to suspend or debar them.
Yeah.
Oh, that's just the
procurement.
state procurement.
No, I mean, if it's a contract that we're into, then we can move to suspend or
Do
debar.
that. Can you do it formally as well as informally?
It would have to be a formal
But
process.
so there is, so where do you rely on that legally to do that? Is it because it's in the contract or it's in your?
It's in the code, as far
In
as,
the Utah code? Or
yeah,
in-
for suspension and debarment, yes.
So the board even can do it, even though the board, just because the board is an independent now procurement office, kind of?
The board could go for suspension or debarment for any contracts that we're a party of or that we oversee. But because we don't have any procurement authority over any of the LEAs or charter schools, we have no rational grounds to
Oh, so
hold
these
any
are
of
only
those.
contracts that the USBE has with,
Correct.
with
So-
a third-party provider.
So-
So we can do that for our own third-party providers, but not those that LEAs contract with.
The only thing we can do is withhold.
Doesn't do what we tell the LEA to do.
Have we been nervous because we have requirements in contracts?
I think there's some truth there, and I think there's also, I think it's also.
Well, that's what.
Yeah, I think that's somewhat true, but I think it's also just, I think there's been the sense, at least there's the sense that there's nothing the LEA can do about it. So why punish the LEA?
Then why are we here?
I don't know. Well, I'm just not saying we can't make some of this happen. I just think there's been that sense before, and we don't have procedures necessarily in place that have more weight. But we've got to end and give these guys some direction. So Angie,
I guess I just had two questions real quickly. So if an LEA did have a problem, though, could the Division of Purchasing, could they go through Division of Purchasing to do that barment or suspension?
The
Or no?
procurement code says it's the head of the procurement unit, so it would be the head of the individual education procurement unit could do that. Or if they weren't comfortable with that, they could always contract for that debarment hearing up to the
So like
State
Granite
Division of
District could do
Purchasing.
it, is what you're saying?
Correct, yes.
Or the right office at Granite.
Yeah, so if it was Granite, then it could be Jerry Gardner who could hold those hearings.
The second question I had is, if we were at some point, I know your feeling is the LEA has no control, so why would we want to punish them? But if we punish them by taking away their money, then wouldn't they have a lawsuit against the provider for causing them to have their money withheld from us? And I know that that sounds all horrible, but unless you do it once,
Oh, no,
no one
I
ever
think-
thinks it's going to happen,
And I'm not
right?
saying, I'm just saying that's been our frustration because it's not like it's free for the LEA to
No.
then go after that third-party
correct, I
provider.
agree.
That's the challenge. And so you've put this LEA in a catch-22 of you either got to spend a lot of money to go get this, or we're gonna withhold your money while you can't do the right thing. So that's been the challenge. Brittany?
So I would make the committee motion
Bless your heart.
to have staff look at a rule, if a rule, wherever that may land.
Maybe it's
an
beefing up
existing, yeah, maybe it's an existing rule or a new rule that would put some contract requirements in rule for LEAs contracting with third-party providers. And what was the other one?
Training?
Oh, and to look at the charter school authorization rule, to put some of those same requirements in, so contracts that may have been in place prior to a 501c3 applying for a charter, that there be certain criteria or requirements that they have to show documentation for, et cetera. And so my recommendation, I'm getting wordy in a motion, but recommendation using the state charter school board's current practice. And then look at the development of some procurement training documentation, not just trainings, but, a guidebook, a resource for LEAs to be able to reference in times when they need it, so.
And can I add to that, because we're just giving direction to staff? I would also look for, Zach, the trainings you mentioned are, yes, available and yes, free, but they're sometimes far too global for what LEAs need sometimes. I would ask your staff to look at an outline, a training outline that you could provide for LEAs to facilitate their procurement, their appropriate, their legal, consistent with the law procurement activities.
And I would add best practices for contract negotiations, right? So we'll have in rule what kind of some of those basic criteria are, but what are some, a little bit more extensive information on how to negotiate a contract that's favorable to you as an LEA.
And one of them might be, like I said, one of the things that's in these notes is to say, if you're doing a contract for more than $5,000 in 2 years, you use an attorney. And I'm not feathering my own nest. I'm just saying that you can't expect a soccer mom who wants to start a charter school to know how to negotiate a contract, and a little bit of training doesn't help.
Yeah, but we probably don't want to require legal counsel, but I would
Some of these
just say.
states do.
But I would just say, require, here's what it is, and in the training, that they recommend that you seek legal counsel for, to have your contract look at prior to enter it.
So it doesn't really help me. What are you gonna say, Cindy? You've
Well,
been patient.
just in response to that, I mean, one of the things we discussed in the task force too was possibly seeking some additional funds to provide authorizers more specific expertise in legal
support so they could help the schools that they authorize. But then our districts need that too,
I was gonna
quite
say, I
frankly.
would rather
It's-
have it.
It's everybody. But I'm going to say something totally different.
Okay.
And we have been focusing predominantly on finances today. And I'm wondering if we want to, when we're looking at these best practices or new practices that other states are doing and this new federal, these new federal insights that we're getting from their study, if we want to kind of narrow the scope to these critical functions for these third-party providers that provide like, you know, finances and administration and instruction, like the key things that make a school, not like they're going to lay the cement in the front
No,
yard.
I agree.
You know what I mean? Like really focusing on those critical functions,
I agree.
those contracts.
Well, I believe they all fall under the same code, right? Because it's services.
Well, as we look forward toward these new requirements,
The
how far are we
criteria.
going with those is my question. With new
This goes to
potential
the issue of
requirements.
Subrecipient versus contractor, is that right?
I know we can't get in too much to it today, but I think it's worth at least having a conversation about or thinking about.
Yeah, can I clarify? Because
Yes.
in my motion, so let me share what my thoughts are in this motion.
Yes, as long
'cause-
as I can come back, because I haven't got to my part
Okay,
yet. My
because,
point.
because certain criteria in a contract, to me, are the same, whether it's educational services, financial services, or laying concrete. You know, that you're going to have certain criteria that says, you know, right? And so it's being broad enough that the contract negotiations can apply to concrete laying, you know, so capital improvements and services that you're doing in a long-term service type contract with somebody.
Agreed with contract negotiations, but when we need to go in and get information, we're maybe not going to go in for get information from the cement layer. I mean, we may narrow that scope. But to my, let me just finish my original point that I'm asking. I would like to also make a motion to direct staff.
These don't have to be motions, these are just directions to staff.
I would also like to ask staff if they would look at the piece of information that was gathered in the research about states that are requiring those people who are interacting with students with state funds being fingerprinted and having background checks, and juxtapose those precedents that are coming out from other states to what our board rule and state or state code require, and see where we are in that continuum also.
So you're talking about the third-party providers being appropriately reviewed?
If they interact directly with students, if they or their people or whoever it is that's interacting directly with students is safe to do so.
Even if they're contractors as opposed to employees, is what you're saying?
Well, in our board rule, I think we
do
even
that
talk
with
about
background checks
volunteers, but
already.
I'm just saying, if our staff could just go through and look at that and make sure.
I think it is, but okay, yeah.
Can I just try to restate so I understand? Are you just wanting to? Sorry, are you wanting to make sure that our background check requirements apply to third parties? Or are you trying to use that as an analogy
To
for
anybody
something else?
that's teaching students, that's
Yes.
using state dollars.
it's already.
Well, that's already there. It's because it says any educator or contract person, a volunteer that has significant.
Access to students.
So, but we can bring
Significant
that in and just
supervised
show you.
access.
We can do that.
Then
But
we
Cindy-
need to end, but we can bring this up another day, because I see some then exceptions to that happening.
And there are some reasons for those exceptions, but anyway. Let's see. I think we understand, I think we've given you something that's narrower than what we were before, which was our goal. No, I totally.
It's been a long week.
It has been a long week, and I was not hoping to get something super, super narrow, but I was hoping that every time we talk about this, we get a little clearer about what we think might work, and see if you can come up with something, and think, and also maybe have heard in the discussion what we're not interested in. But so anyway, I think that you've got some, to bring back another proposal that then we can review and then we can add to again. I think we've got some discussion about I mean, the contracting stuff will help, but I think we've got to really figure out if we mean all contracts or if we mean certain kinds of contracts. Well, that's what we need to discuss, because I can see a good reason in some ways for that, but they are different. Certain kinds of contracts have to be more complex. Others can be more simple, and because the enforcement of them isn't as expensive. Royce, you've been sitting there all this time. Do you have anything you want to add? Or you're just being amused? Be amused? Okay. No, it's not.
Things you're asking for are already.
Well, I think you're right, and we'll see which things are already there, and I think the 115 maybe has some of those too. But I think we've got to narrow this and then come up with something that's manageable and try again. Thank you. Angie, did you have more?
Just want to kind of make sure we're all on the same page on expectations of turnaround for some of these things.
Okay.
So I think we've got a lot in here, and we do have the holidays in between, and then, of course, the session is coming up. But what I'm probably going to do is ask Ben to work with Zach on some of these, because Jeff and I we're starting to get to the point where I feel like I have to turn my sights toward the legislature, as you can imagine. But we can bring some of this, but likely probably not till February, if that's okay. Okay. And the resource guide, I was talking to Zach about this, because we were talking about what a great document the Department of Education for Colorado had, but that would take quite a while to get ready to. But maybe we could provide an update on how that's going, or what we're thinking about, what that would look like. I did want to ask, related to kind of enforcement or monitoring and training, Leah Voorhees had stated that she's got some data over the last couple of years. As they've been doing their monitoring, they've kind of changed. They've tried to turn their monitoring into technical assistance at the same time. And so she has actually some data that shows schools that they've done monitoring visits with, how their compliance has increased. And so related to one of your questions in October was, for our monitoring staff, what kind of resources do you need? And she is prepared to come either in January or February to talk about what that would look like, what they're seeing as far as their approach is when they go in. It's not just to be a gotcha, but it's meant to be technical assistance. She also mentioned to me the effectiveness of staff actually being on site providing that technical assistance versus somebody coming to a conference for 8 hours,
That's a
right?
really good point.
And so when you start to think about it in that context, you can see why you would need more staff to actually go on site and spend a day or two with them. And so would you be interested in hearing from Leah from that perspective? Okay. I think she said she could be prepared for that discussion in January. So, but we would probably just limit it to that. And Whitney, you may even have some anecdotal evidence of that too in student data privacy. So maybe reach out to other staff in the agency.
And maybe just plant this thought in Leah's mind, could that be done, rather than increasing staff by 3 people, could it be done by some contract employees?
Absolutely. She mentioned that. That's but we have good contracting processes in our office. But no, she actually does have quite a few contractors that they use for special ed. So yes, that is part of the conversation.
That would be really helpful. I can see that. I think we've made more progress than
you anticipate.
Well, than it feels like. So, thank you very much. Meeting's adjourned, right? I don't think there's any more to talk about. Thank you, and thank you, Jennifer, very much for your contribution. We're good. We're not good, but.
No, we're not good.
Well, we're done.
I thought it was good.
It was okay. It just feels like it should be more linear, but it's not. But here's my problem with